Monday. What is Monday. 25th. Yes. B group, Ado. Is it B group? Good. Thank you. What is the GM? KB. Vacating in urgency. You are appearing for the KPTCL. You are appearing for the KPTCL. Whom do you appear for? No, who is that? KPTCL. What is the urgency for vacating the interim order which is granted by this court? No urgency. Yes,
Disposal
I andre?
judgment
Disposal I andre. Togoli memo togoli. Reports. Second appeal. No, labor matters Monday, Tuesday. Yes, sorry. Labor matters on Monday and Tuesday. I totally our BM number.
bank account. We have interest. We are sought for an installment.
You are appearing for union or you are appearing?
Fresh.
The final hearing.
Number 4, number 23. Number 23. Speak, I already informed the other side.
This is a date given matter, right? At request of the appellant counsel, this matter after 2 weeks.
Number 5, number 24 to 27. Page number 6, number 28 to 33. Page number 7, number 34 to 40. Page number 8, number 41 to 46.
For the appellant or the respondent? Yes. He is not well. Let's respond. Next week after vacation, you take your chance. Then at counsel for the respondent submits. You're Dayalu. Who are you? What is your name? Mohan Kumar submits that he is unwell. At request, is this matter? Week after next. You are appearing for the appellant. At request of the appellant counsel, this matter after the ensuing Dasra vacation. Admission matters. You are appearing for whom? Appellant. At request of the appellant, this matter. When do you want? After ensuing Dasra vacation. 2024. Serial number 4. Correct. Now see, most of the matters in a specific, yeah, only one submission, one query, or rather one doubt of this court. All the time in a suit for specific performance of contract, what happens? You say that there is an agreement, right? And then the possession is already been taken by the respondent, and you say you still have a right to argue this matter. You contested the execution proceedings. After contesting, you now press for this. No, after contesting the execution proceedings, then you should have no, then you should have pressed this. You memo haki idralli registry-nalli. This matter at request of the appellant counsel on 26th. Yes. Emergent notice to the respondent, stay of the impugned order, subject to the petitioner depositing 50% of the enhanced amount with interest, with proportionate interest from today for the trial court within 4 weeks.
My lords, I am appearing for the petition, my lords.
What is this, madam?
My lords, the petitioner is seeking for writ of mandamus to consider the representation as per Annexure Q. That is the grant of CL-7 license, my lords, fresh grant, my lords.
And this representation,
My lords, this thing started in the year 2021, my lords. Every year he is filing the application for fresh grant, my lords. Till now, they have not considered, my lords.
Madam, you have to file this application before the appropriate authority.
We have already filed it, my lords, only for writ of mandamus to consider as early, my lords.
The CGP submits that.
Please.
There are one is, what is that?
My lords, Annexure Q, page number 60, may kindly be seen, my lords.
They have made respondent number 4 and 5 as parties, that is Deputy Commissioner of Excise and
Please,
Deputy Superintendent of Excise. Now, according to you, this Deputy Commissioner of Excise, there
Please,
are two. There are 8 ranges. Correct. Where is that? Where is that? Strangely, for unknown reason, we are forwarding the application to the third respondent. No, you forward it. No, you forward it to range 1. That you can do it, right? No, you have not written on that ground. You have written on. No, where is that? Where is that? No, document Bekala. See, they have said as per Annexure L. Let us read Annexure L then. What does Annexure L say? Correct. Correct. So that was the reason. That was the reason you have now. No, you transfer. They don't know against before whom they have to give a representation. The common people, they would not know. Alva. See, what you should do, if a representation is being given, you should give it to these appropriate authorities. How do you ask them to go and submit? Now, who is the range officer? Have they made him as a party yet? Then.
Please, my lords, respondent inspector of excise, he recommends the documents, my lords.
So he has given they have given representation to respondent number 3. Deputy
That is,
Commissioner.
please, my lords, that is the licensing authority, my lords.
He is a licensing authority, right?
Please, my lords.
You have to make an application. You will forward it to the respondent number 3 for consideration.
Correct. Now they have already given it to respondent number 3. ಇದು ನಿಮ್ ಪ್ರಕಾರ ಪ್ರೊಸೀಜರ್ ಇಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲಿ ಹೋಗಿ ಇಲ್ಲಿ ಹೋಗಿ ಆಮೇಲೆ ಇಲ್ಲಿ ಬನ್ನಿ ಅಂತ. They have already come to deputy. This is deputy commissioner, respondent number 3, who is the licensing authority, alva. He has to consider, alva. Then where is the question of going and giving it to range officer? We'll say you consider and pass. Already it is there before them.
Just come back the
ಅಂದ್ರೆ ನೀವು ಹಿಂಗೆ ಹೋಗ್ಬೇಕು, ನೀವು ಹಿಂಗ್ ಹೋಗ್ ಬರ್ಬೇಕಂತ ಹೇಳ್ತಾರೆ.
My lords, directly that cannot be done, my lords. After the verification of the documents, it has to go through through proper channel, my lords.
Correct. That is what he's saying. You have to submit a representation to the range
My
commission.
lords, it is, my
Range
lords,
one.
annexure Q may kindly be seen, my lords. Page number 60, my lords. Abakari Nirikshakaro, he recommends for granting of license after verifying all the documents, my lords.
Annexure Q is issued by whom?
Annexure Q, it is our representation, my lords.
Madam, directing the respondent number 3 to consider the application of yours is your.
Please, my lords.
Yes.
As per annexure Q is our representation. They have to consider our representation as per annexure Q, my lords.
Correct. Huh? Yes, what they say, you have to give an application to the range of range 1, range officer 1. Is it so, madam?
No, my lords. No, my lords. Whatever we are given the proper Hasana Valaya number 2. That is Hasana. That is the range inspector, my lords. He forward the documents to the.
Dispose of and say that this is the appropriate authority, or let him say. The grievance of the petitioner is the non-consideration of the application submitted by the petitioner for grant of license in form CL-7 at annexure Q before the respondent number 3 licensing authority. Learned SCGP submits that if some reasonable time is granted by this court, the same would be considered by respondent number 3, the licensing authority, in accordance with. The said submission is recorded. The grievance of the petitioner would be meted. If necessary, direction is issued to the respondent number 3 to consider the representation. And the petition stands disposed of, directing the respondent number 3 to consider the representation within an outer limit of 4 weeks.
My lords, 3 and 4, my lords.
What 3 and 4?
Deputy Commissioner, now it is delegated to Deputy Commissioner of Excise. That is the licensing authority.
ನೀವು ಹಂಗೆ ಹೇಳಲೇ ಇಲ್ಲ, 3 ಅಷ್ಟೇ ಹೇಳಿದೆ.
It is said, my lords.
Where is it?
My lords.
Where is it said?
My lords, issue writ of mandamus or any other appropriate writ or direction directing the respondent number 4 to place the application of the petitioner for grant of CL-7 license in terms of the representation.
But then respondent number 4.
3 has to consider, my lords.
The grievance of the petitioner is non-consideration of the representation submitted by the petitioner in CL-7 in terms of the representation at annexure Q. Annexure Q and dated 21/8/2025. The application is filed before the respondent number 4, Deputy Commissioner of Excise, seeking direction, Excise, and the proper authority to consider the application is the respondent number 3, licensing authority. The petitioner seeks direction, seeks a mandamus to direct the respondent number 4 to place the application of the petitioner for grant of license in form CL-7 before the respondent number 3, licensing authority, and in turn the licensing authority to consider the representation, consider the application of the petitioner for the grant of license.
We forward it to the deputy.
Now they have filed it before the, correct now, ಈಗ R4 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಆಫ್ ಎಕ್ಸೈಸ್. Where is that? Annexure L does not say anything. Then how are we supposed to know?
As annexure L is the last year communication, my lords. That is 2022, my lords.
Did you produce that annexure L? There is another communication which they have given stating that you have to go before the range officer, and in turn this range officer will give this to the licensing authority.
Please, ma'am, that is 21/8/2024 annexure Q, my lords. Abakari Nirikshakaru.
The SCGP submits that the proper channel to be followed is by making an application to the range officer, excise officer, range 1 and Hassan district. And the said officer would in turn forward it to the licensing authority respondent number 3. The said submission is recorded. In view of the same, the petitioner to make an application before the range excise inspector, range officer, range 2, range 1, and the range 1 of and the said inspector to forward the application of the petitioner to the respondent number 3 licensing and the respondent number 3 licensing authority to consider the application of the petitioner within an outer limit of 8 weeks from the date of release of this order.
Please, my lords.
If the order is passed, they will do that work of transferring it. Yes, yes.
Grateful, my lords.
ಅದು inspector ಅದೇನಿದೆಯಲ್ಲ, range 1. Inspector. Excise inspector. ಹಾ. Correct. Mr. Consul, that court expressed its inability. Correct. That is how this matter came before this court, right? What?
For the expiry of 30 days, it cannot be taken up. Therefore, it has been.
No, that is, yes.
But if you want to say anything, think that very serious matter. But I wanted to say this. He's a respondent in these proceedings. It's a case of forum shopping. But what happens? Some of the defendants approaches the writ court as against the ex parte order passed by filing a writ petition on 27/8/2024. The matter comes up before the coordinate bench. Coordinate bench doesn't grant the interim order. Then the MFA is moved. The MFA without the other bench is not before the matter is then afterwards put before your lordships. The counsel who appeared on behalf of the petitioners appears not in this matter. Not just kindly have a look at the order sheet. Respondent number 4 to 7 are the petitioners. They appear before the court. Doesn't bring to your lordships notice that the writ petition has been filed challenging the very same order where the honorable court, the coordinate bench is not granted an interim order, and pursuant to your lordships pronounced to grant an interim order in the matter. It's a case of forum shopping, but I don't want to get into all those things because I know the repercussions with which this may spill over. It's a suggestion. What your lordships have directed is that we are demolishing the constructions is what your lordships have observed. But in this guise, what they are now doing is 4/9 your lordships passes an order, 5/9 puja takes place. All the building materials are already lying in these properties. This belonging to me is my case before the trial. If they are permitted to change by virtue of your nonsense order minutes, ultimately again there is a defeating of my rights. The matter is still not launched before the trial court, but they have filed their objections, they have argued the matter. The other defendants have also filed their objections, they have argued their matter. Some of the other defendants came on the last hearing date and the matter is now posted on. But it was actually posted on 39th for hearing. It so happened that since there was an interim order in the interim now, but they used the different numbers 1 to 4 produced the memo saying that your lordships have passed an interim order, not the difference number 6 to 9 who are now before the sorting. I was my
Mr. Consul, when somebody is arguing, please.
Now the trial court says that since this honorable court has granted an interim order, I am not considering trial number 1 and defers the matter for consideration. The hearing also does not take place on 39. Otherwise, the hearing would have taken place by now. Now, I would suggest this not to read about the points. Let both the parties be directed to make the status quo and let the trial court not as per the statute proceedings. Higher numbers 1 and 2 here on the merits they decide. If they want to take it on the merits, making a statement, this is pure and simple case of forum shopping, where the court has to take a very serious cognizance of it. Because from time and again, the court has said that forum shopping is the worst form of interference with the administration of justice. It is to be dealt with an iron fist. But I don't want to get into it. If they want to say that, I am not going to get into it. Because I know that the repercussions may even get into the bar.
They said forum shop. Only to that extent, I'll make a clarification, to that extent.
Why did you not bring to the notice of this
Even
court?
I am not aware of, my lord, even I am not aware.
Why did you not bring to the notice of this court
No,
that
I
there
am
was
not
a
party to the litigation, I am not even aware, my lord. I have filed a MFA, my lord, I have filed a MFA.
So appear on point number 4, 5 to 7 as you not said the first line in the order. It also appear for rate petition.
Where is the copy of the writ petition?
But it's going to happen. Page number 10. And the order is at page number 25.
Okay,
When they want the
just a moment, let us understand what has happened. Now, this KV Prasad, they are defendant number 1 to 4.
maybe Prasad is different number 1 to 4.
Ah,
They have come before this honorable court on the date when your lordships have granted an interim order on 4/9/2024. Which your lordships have observed.
yes,
Without issuance of notice, they appeared before the court. Wasn't there a
Yes,
responsibility to bring your lordships notice that this is what has happened? But
Yes.
this is not fair. I'm giving a wider syllabus, the counsel for you get into this controversy are not any country. Their best interests are suggesting that let both the parties maintain status quo for a period of 30 days. We go before the trial court and the trial court can dispose of the applications.
Let the trial court dispose of the application. Because the plaintiffs are the ones who are my vendor.
when you entered appearance before this court,
I was not physically working.
who, why did he not make, why did he not make? What is the question, sir? What is the question of submitting that inadvertently he has not made a
Those
submission?
are instructions to make that. Which is why I asked.
Then this fact was aware, this fact was brought to the notice of you also, right? You were aware about this?
No notice is served, my lord. No notice is served. My lord, my MFA is much earlier to the filing of the petition, my lord. Kindly see the date, my lord. Kindly see the date,
When was the order passed in the writ petition?
29th, my lord. The
29th.
writ petition is filed on 29th. My MFA was filed on
When
23rd,
was the order passed in the writ petition?
29th, my lord.
29th?
Date.
You should complete the sentence, right? You should complete the date.
29th, 8, my lord. But I have not received any notice till today, my lord. That writ petition.
We will observe that now. We will observe to the effect that this was not brought to the notice of this court while granting this.
Because let me make one submission. Let me
There
make
has
one.
to be fairness before
No,
the.
no.
There cannot be a mistake knowingly you have committed. When you knew that this writ petition is this MFA,
I paid for the society, I cannot suppress that.
My lord. My lord, I appear for the purchase. We are not appealing for the one submission, my lord, only to that extent clarification. That there been a status quo, let it be disposed of within 30 days without insisting of service of summons of defendant number 5, my lord, only because service of summons has not been taken place on defendant number 5. The court adjourned the matter on 30 May, my lord. My lord, when first time the matter came up,
not 13, and which matter you are talking about now?
and I was before the trial court, only
So that we've noticed in the order.
only for that reason only, that was a 7 days was a
That
time.
was the impression you created upon the court, saying that in light of the notice being not served upon those respondents, the trial court is not taking up the matter, and you have put up the building materials, and there are chances of.
Kindly see the photographs, my lord. Kindly see the photographs. It is not that they are separate. My lord, 100 feet road is formed already. 100 feet road is already formed much prior to filing of the suit. I have printed the photograph before this court, my lord. They demolished the, after obtaining the interim order, they demolished the compound wall of my neighboring site.
Yes.
Kindly see the matter.
What aspect?
My lord, let there be a maintenance of status quo within 30 days without insistence of service of summons for the defendant member. Right?
Making allegation is easy, but to sustain it will be very difficult. Paragraph number 5, you know, top 5, maybe it's the application, you not suspect anything. Or transferred before the trial court. Trial court has heard the matter. But the second
Para
sentence,
number?
the case was adjourned to 15. Defendant number 6 to 10 advanced the matter to 28/8/24. Filed objections and written statement. Defendant number 6 to 9 submitted that he would try to pursue at other differences come on record. Hence the case was pushed to 38. On 38, defendant not for appeared while objections to the application was also argued the matter. Defendant 8 to 10 also filed Wakalan sought time to file objections. Case was adjourned to 29. On 29, defendant number 10 to 12 filed objections. Case was posted for hearing on the maintenance on 39/2024. So that statement is not correct.
My lord, I
We are addressing arguments in the matter. We are not awaiting because I expect you to that things of the defendant. Some of them are entitled to certificate
from 2-9, it was
What was the suit for?
for declaration,
clearance and injection.
for cancellation of savings and injunction.
What was the injunction sought?
Injunction sought was not to interfere and not to alienate. Item number 1 is not to interfere. Item number 2 is not to alienate.
Not to interfere. IN number 1. And IN number 2?
No, item number 2 not to further alienate.
Not to eliminate. What did the trial court do?
But trial court has granted an interim order in respect of both ex parte and interim orders granted on item number 1 and 2.
IN number 1 and 2.
Yes.
So not to alienate and not to interfere. Which is that order?
That's your process with page number 48.
That's the interim order at page,
48.
Sorry. From page number 20. Sorry, page 20.
Yes. Then after this, they filed an application. So when was
After this, on 23/8, they have filed the amendment.
when was this order passed?
This was on 14/8.
14.
On 23/8, they filed the amendment.
Not even filing an application for.
Yes. Without even entering the appearance, then they filed an amendment. And just read the button. What the position of law in this regard. Paragraph number 21. So that's the F because if in such circumstances, in para 21, the party which does not get justice to the inaction of the court in following the mandate of law must have a remedy. So we are of the view that in a case where the mandate under 30 days would be, which requires 30 days, the court is counted, the agreed party shall be entitled to the right of appeal, notwithstanding the pendency of the application for grant or vacation of temporary election against the order remaining in force. Such an appeal preferred to appellate court shall be expected in the appeal. The earlier part of it says that the appeal has to be filed only against the order passed, but the Supreme Court said you have to wait for 30 days after your appearance. After order 39 goes 3 years, then you will get a right of appeal. So MMA could not have been filed as on 23. Anyway, because I don't want to get, because I understand it will go somewhere else.
My only apprehension was a demolition.
My learned is also considering, so I don't want to go beyond that. Participate direct all the parties to maintain status quo and the draft will be directed to the
You appear for
We don't
respondent
right
number.
of service of other dependents, my lord, because the property has been sold. The dependent covered by summons is not served. And it was for trial court urgent the matter only for await of, for hearing and await of events.
What application you have filed before the trial court?
We have made an objection.
So let the IA be considered on merits, considering the objections filed by you, and let an appropriate order be passed by the trial. We cannot direct the trial court. In the consideration of the IA, let there be an order of status.
So 39(2), the court can set it. It is in case of a 39(2), Supreme Court has said, in 30 days it has to be disposed.
The defendants 6 to 9 are before this court seeking to set aside the ex parte order dated 14/8/2024, passed in OS number 125 of 2024 on the file of the second additional senior civil judge, Bangalore, rural district. Yes, please. Bracket number. The respondent number 123 instituted suit for cancellation of the registered sale deed dated 19/8/2017. For declaration,
There's no declaration.
declare that the sale deed dated, for declaration that the sale deed dated 13/9/2020. So what is that consequential? So the registered sale deed. Seeking for cancellation of the registered sale deed dated on file, and for declaration
And consequential relief.
cancellation of the registered sale deed and the consequential reliefs. Along with the plaintiff filed applications I-1 under order 39, rule 1 and 2 CPC, seeking an order of temporary injunction restraining the defendants from interfering with the peaceful possession and enjoyment of the suit. And I number 2 under order 39, rule 1 and 2, seeking an order of temporary injunction to restrain the defendants from alienating the suit schedule property. The trial court, by the impugned order, pending consideration of I number 1 and 2, issued an order of ad interim ex parte temporary injunction restraining the defendants from interfering with the peaceful possession and enjoyment from alienating the suit schedule property till the next date of the appellants approached this court contending that the plaintiffs the appellants have put up construction over the suit schedule property And in light of the order passed by the trial court, the plaintiffs, by respondents 1 to 3 herein, are trying to dispossess the appellants, dependent number 6 to 9, and trying to demolish the construction put up in the suit schedule court. The next one. And taking the note of the submission made by the appellants, this court granted an ex parte interim order. This court stayed the execution of the order dated 14/8/2024, passed on I number 1 and 2. The respondents have entered appearance, all right? All have entered, have entered appearance. Which is that memo? As order sheet memo. Memo is filed order sheet. Memo is filed by the appellant seeking for dispensation of notice to whom? 8 to 11. Memo is taken on record. Notice to respondent number 8 to 11 is dispensed. The respondents 1 to 7 have been represented by counsel. Then it, D.R. Ravi Shankar, then its senior counsel appears for respondent number 1 to 3. So and so counsel appears for respondent number 2 to 7. Third, the application filed by the plaintiff, I number 1 and 2. To the applications filed by the plaintiff, I number 1 and 2, the appellants have filed objections, and the IAs are pending consideration. The interim ex parte temporary injunction was granted till the next date of hearing. And in light of the pending consideration of I number 1 and 2, this court feels it appropriate to direct the parties to maintain status quo till the consideration of the application I number 1 and 2 by the trial court. And with the said observation, the appeal stands disposed of, directing the trial court to pass appropriate orders on I number 1 and 2 by considering the objections filed by the defendants in accordance with
30 days. Supreme Court says within 30 days. Supreme Court says in case of a 30
in accordance with law, and we have said, right?
So far as
What does it mean in accordance with law? The trial court will pass orders.
this has not been served on the defendant, for that reason only it was urgent.
The
Without insistence of service of
orders to
notice.
be orders on I 1 and 2 to be passed expeditiously, considering the settled propositions of law. Yes.
So now the defendant number 5 is not served now. They have filed again impleading application.
Yes.
Supreme Court direction clear ಆಗಿ ಹೇಳ್ತಾರೆ 30 days only dispose of ಮಾಡಬೇಕು ಅಂತ.
ಅವ್ರು ಮಾಡ್ತಾರೆ, ಅವ್ರು ಮಾಡಬೇಕು. After your appearance, they have to do it, right?
Quantified objection.
Yes, I said, right. We have already said, Mr.
Again, the service of summons is there for other defendants.
By then, Mr. Counsel, by then there is an order of status quo. What is the harm that is going to be passed? Yes, yes.
Transaction is now. We are the most affected one. 20 days direction will be.
So, Counsel, you want this court to say anything about that writ petition which has been filed by the respondents, and you did not bring to the notice of this court? You want this court to observe anything? Then. Yes, SCGP is directed to accept notice for the respondent. Huh? Order sheet nullity. First. Second matter nullity. Yes. ನೀವು ಮೊನ್ನೆ ಹೇಳಿದ್ದೀರಾ? Request of the appellant counsel to file memo for withdrawal. This matter on 26th. What is the suit for? Application under 7 to 11D. Okay, how was the suit maintainable? Yes. It was conclude this matter after 2 weeks.
Number 7, Procedural of opinion.
Or you are the counsel appearing for Siddhamallappa. You are also the proxy counsel for this matter also. You are a proxy counsel for all the matters. Then on after 2 weeks. You will the appellant counsel.
Number 8, CH-27.
When the counsel submits that the appellant counsel is under this matter after 2 weeks.
Number 9, CH-27.
For declaration and mandatory injunction was filed. That was dismissed. The plaintiffs first appeal also.
You are the plaintiff, You're the plaintiff, right?
Yes, plaintiffs second appeal.
The suit for?
Suit for declaration and mandatory injunction to remove the mud wall put up by the defendant to the extent of 1.5 feet to 45 feet.
What is your title? How, on what basis?
I have produced the exhibit P4 in my sale deed. Both the courts dispute my suit only on the ground that in the sale deed my measurement of the purchased share is not mentioned.
Is the main?
But your lordship kindly appreciate the fact that this defendant has not disputed the boundaries of my property. In view of the boundaries prevail over the measurements. Therefore, in my submissions, both the courts erred in dismissing the suit on that ground alone.
Where is the issues framed by the trial court?
Page number 83, issues lots of the trial court statement. May I read? Whether the plaintiff proves that he is the absolute owner of the suit scheduled property, whether the plaintiff proves the alleged illegal construction of the support involved by the defendant in the suit scheduled property as contained in the written statement, whether the plaintiff proves that he is the peaceful possession and enjoyment of the suit scheduled property as on the date of the suit, whether the plaintiff proves alleged influence from the defendant, whether the plaintiff is entitled for the relief of mandatory injunction, whether the plaintiff is entitled for the relief of permanent injunction, for what declared. These are the issues.
Come to the reasoning.
Please. At page number 85. Since these issues involve in common discussions, they are taken together for common consideration to avoid repetition. The entire burden is on the plaintiff to prove their case and also to prove these issues. In order to prove the same, the power of the attorney holder of the plaintiff got examined as PW and he filed affidavit in lieu of oral chief examination by reiterating the plaintiff governments. He deposed that he is the brother of the plaintiff and the suit scheduled property totally measuring 45 feet by 65 feet of Velur village was purchased by the Nilakanta from his vendor Uchama, and during 1974 the said Nilakanta who had no issues, left the village and he was unheard and deemed to be dead. And his wife Gaurama also died, and it is in the year 1986, the sons of Renuka Rajya had filed a suit in OS number 144 of 86, and the same was ended in a compromise, and in the said compromise petition, the certain portion of the suit property was allotted to B.R. Puttaswama Rajya, and the northern half portion
What
was
is-
allotted to B.R.
Mr.
Renuka Rajya.
Mr. Consul, what is the measurement of, the scheduled property
Scheduled property is
standing in the name of your vendor? What was
that
the
is half portion, that is 45 feet by 32.5 feet.
Then how are you entitled for 41 into 65 feet? That was the question.
Because I purchased
What
from
the-
my sale in exhibit P4, this 17/7/2003. What the Puttaswama Rajya got in this compromise, the entire portion was purchased by me. There is no dispute. That's what both the courts observed, that the original measurement 45 by 65 is not in dispute. Each parties in OS 146 compromise and half share they got it. There is no dispute. What the dispute is, the remaining, the other side, which is Renuka Rajya got the half portion.
Mr. Consul, how could you have purchased? There is no measurement in your sale deed.
Yes, I do. But your lordship will kindly appreciate the fact.
And then
Original measurement.
how are you,
Sufficient.
how are you in possession of a property which you are not owner? You are owner, you say that you are in possession?
There is no dispute that I have purchased from Puttaswama Rajya half at an extent, 45 by 65, which they entered into compromise. There is no dispute. That has been described by giving the boundaries. The defendant has not disputed my boundaries. Therefore, I am entitled for
What
45 by 32.5. There is no dispute about it. What he purchased, the defendant has purchased from the Chelvaya has purchased from Renuka Rajya. He had 3 sons. He made it 1/3 portion to each son, and that 1/3 portion has been purchased by this defendant on the southern side of my property. Therefore, yes, while demolishing that old house, he has encroached 1.5 feet by 45 feet. That is my case.
How are you entitled for an excess extent of the only question?
90%. I'm not disputing that. There is no dispute
No,
with
that's
what I have purchased. I am seeking that my case is he has encroached from the southern side 1.5
What
feet.
is your right? What is your right over that property?
That is purchased by me.
Where is that?
45 feet by 32.5 is purchased by me. Exhibit P4, I have produced my sale deed.
Does your sale deed indicate the measurement of the property?
I do admit that it doesn't mention measurement, but there is no dispute between my vendor how much he got in the compromise. There is no dispute with respect to the boundaries, but whether it is less or more, the boundaries are 4 corners. Whatever I have got the right. Therefore, my case put forth by this is, look here what I have purchased. My defendant has encroached to an extent of 1.5 feet by 45 feet by demolishing, and he has put up this. Therefore, I have sought for removing the mandatory injunction. For that purpose, I have filed this suit. That's all the case.
Considering the concurrent findings of facts recorded by the courts below, the plaintiff will depose this court in the regular second. The parties herein are referred to as per the rank before the joint court for the sake of convenience. Suit property. Suit property is a vacant property number 531. Bearing number 531, property number 12/17. Measuring east-west 45 feet, north-south 32.5 feet. Bounded on east road, west backyard of Dasaya, north half share of Renuka Aradhya, south northern half to the house of Shankara, related to page number 120. Herein referred to as suit property for the sake of convenience. Suit seeking for relief of declaration, declaring that he is the absolute owner of the suit property, for mandatory injunction, directing the defendant to remove the supporting wall of his house to an extent of 1.5 feet into 41 feet on the southern edge, and to remove the protracted area of 1.5 feet and 41 feet on the northern side of his house, and for consequential relief of permanent injunction, restraining the defendants from interfering with his possession and enjoyment of the suit property. Plaintiff was that the plaintiff purchased the suit property, which was suit property, totally measuring 45 feet into 65 feet. The plaintiff was that suit property was purchased by Neelkanta Aradhya from his vendor, Uchama, totally measuring 45 feet into 65 feet. And during the year 1974, he said Neelkanta Aradhya, who had no issues, left the village and he was unheard. And in the year 1986, the sons of Renuka Aradhya had filed a suit in OS number 144 of 1986, and the same ended in compromise. And in this compromise petition, the southern portion of the suit property was allotted to B.R. Putta Soma Aradhya, and northern half portion was allotted to B.R. Renuka Aradhya, and Khata was mutated in the respective names. The case made out by the plaintiff is that B.R. Putta Soma Aradhya, along with his sons, sold the property to B.R. Uma Shankara Aradhya under register sale deed dated 17/7/2003, and the khata has been changed in his name, and he is in possession of an enjoyment over the suit property as absolute owner. Further, that the property abutting to the south of the scheduled property, suit property, was originally country tiled house purchased by Chalvacharya from Revana Aradhya and his son, and subsequent to his death, his two sons divided the property equally to an extent of 15 feet, and the defendant has purchased half share of B.C. Prakasha Acharya, measuring 45 into 15 feet. 15 feet. The plaintiff contended that the defendant has absolutely no manner of right, title, or interest over the property of the plaintiff to construct a wall within his property, and hence the present suit. Next panel. On service of notice, the defendant filed a written statement, and inter alia contended that the defendant is the absolute owner of the property, and he has not enclosed the property, and he has purchased the property under register sale deed dated 10/10/2001, and the plaintiff has and the plaintiff's suit is not maintainable and sought for dismissal of it. The trial court, on the basis of the pleadings, framed the following issues. Page number 80. In order to substantiate their claim, the power of attorney holder of the plaintiff was examined as PW1 and one witness as PW2. Marked documents at exhibit P1 to P9. On the other hand, the defendant examined himself as DW1 and one witness as DW2. Dot marked documents at exhibit P1 to D7. The court commissioner was examined as CW1 and the report of the commissioner was marked at exhibit C1 and C1A. The trial court, on basis of the pleading and oral and documentary evidence, arrived at a conclusion that one, the plaintiff has failed to prove that he is the absolute owner of the suit property. Two, that the plaintiff failed to prove the alleged failed to prove any illegal construction of supporting wall by the defendant in the suit property. Three, that the plaintiff failed to prove he is in peaceful possession and enjoyment of the suit property as on the date of this. By the judgment and decree, the trial court dismissed the suit of the plaintiff with cast. Aggrieved, the plaintiff preferred appeal before the first appellate court. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, concurred with the judgment and decree of the trial court. Heard the learned counsel appearing for the appellant and produced the material one. The burden is on the plaintiff to establish that he is the owner of the suit property, totally measuring 45 into 65 feet. Owner of the suit property. The plaintiff examined the power of attorney holder as PW1. Exhibit P2, P4 are the sale deeds. Exhibit P5 to P and 6 are the kata extracts. The plaintiff deposed that he has purchased the property under register sale deed on 7/7/2003. And the kata has been changed in his name and he is in possession of the suit property. The defendant admitted that the plaintiff has purchased the property towards the eastern side of his property and he is in possession of the purchased property. The defendant seriously disputed the measurement of the suit property. According to the defendant, the plaintiff purchased the property measuring 41 into 31.5 feet and he is in possession. And the plaintiff is claiming an excess extent by filing the present suit. PW1 in his cross-examination admitted that the defendant has purchased the house property measuring 15 into 41 feet. The defense set up by the defendant is that the property purchased by the plaintiff is not measuring 45 into 32.5 feet, and the plaintiff is not in possession of the said extent. The plaintiff has to establish that he has purchased the suit property to the extent as mentioned in the claim. Exhibit P4 is the sale deed wherein the measurement of the suit property has been disclosed. It is the case of the plaintiff that his vendor has acquired title of the suit property under Exhibit P3, and he has been allotted 45 into 32.5 feet. Exhibit P3 does not disclose the measurement of the property allotted to the vendor of the plaintiff. And neither the document discloses that out of the entire extent of the property, half share was allotted, and remaining half share was allotted in favor of Renuka Aradhya and others as per the complaints. Exhibit P2, the sale deed does not disclose the original owner, Neelkantha Aradhya, purchased the property measuring 45 into 65 feet with specific boundaries. The Exhibit D3 to D5 are the documents which are produced by the defendants, which falsifies the case of the plaintiff. Exhibit D3 to D5 are relating to the suit property which was standing in the name of vendor of the plaintiff, wherein the measurement of the suit property was disclosed as 42 into 31.5 feet. The plaintiff has not produced any documents before the court to rebut the documentary evidence marked at Exhibit D3 to D5, and to prove that his vendor is the absolute owner of the property and alienated the property under Exhibit P4. Exhibit P4, the sale deed, the plaintiff claims to be in possession and enjoyment, does not indicate the extent of measurement. The report of the court commissioner discloses that the plaintiff is in possession of the property measuring 45 into 64.2 feet. 64.2. The trial court, on assessing the entire oral and documentary evidence, arrived at a conclusion that the plaintiff has failed to prove his lawful possession over the suit property within the boundaries and measurement disclosed in the plain sheet. The first appellate court, being the last fact-finding court, we appreciated and reconsidered the entire oral and documentary evidence and arrived at a conclusion that the plaintiff has failed to establish his ownership to an extent as mentioned in the schedule. The manner in which the courts below have assessed the entire oral and documentary evidence. This court is of the considered view that the same does not warrant any interference under Section 100 CPC, and no substantial question of law arises for consideration in the present appeal. And this court passed the following note. The regular second appeal is hereby dismissed. The judgment and decree of the court below transferred.
Yes, Prakash, Hari.
The trial court of the trial dismissed the suit against which an appeal was filed. During pendency of the appeal, that the appellant died on 24/7/2016. That was not brought to the notice of the court by the counsel of the party. The LR application had not been filed and it was decided on merits. Ultimately, the upper first appellate court dismissed the appeal on 7/11/2016. So that the judgment and decree passed by the appellate court against the dead person, the nullity in the eye of law. Therefore, I made certain applications. One application for recalling the judgment and also another application before the first appellate court. First appellate court has dismissed those applications on the ground.
File those applications, you should file those applications before this court as well. You can't directly come on record, you have to make an application.
Filed this appeal, seeking leave of this honorable court to file the appeal.
Right?
That is the procedure.
Correct. There is one more procedure wherein an order is against a dead person, so the LRs were not brought on record.
Yes.
So the LRs have to be brought on record before the court first appellate. So then an application, but an application has to be made before this court as well. Anyway, notice is ordered to the respondent,
What is his order?
who appears for the respondent.
My submission to your lordship is only for the first appellate court I can make it.
Right? But in the event, you have to.
This appeal seeking leave of this honorable court, and that application has been allowed.
Yes.
I have included the LRs and parties. This appeal.
What is the substantial question of law?
One of the questions, and on merits also, whether this is a granted land in favor of Kenchappa Sanna, that Kenchappa Sanna, Periyappa, whether the defendant, the father's name of defendant 3 to 5 is also Kenchappa, but his father's name is Sannakariyappa.
The limit counsel for the appellant. Limit counsel for the appellant submits that during the pendency of the regular appeal, the appellant plaintiff died on 24/7/2016, and the death of the appellant plaintiff was not brought to the notice of the court, and the appeal has been heard and dismissed on merits. Counsel submits that the LRs of the plaintiff filed application for recalling the order and also for bringing the LRs of the appellant by plaintiff on record, and the said applications have been dismissed. And the present appellants are the legal heads of the deceased plaintiff, challenging the judgment and decree of the trial court and the trial court, the first appellate court, and the first appellate court judgment and decree being against a dead person is nullity in the eye of law. The matter requires consideration. The appeal is admitted to hear the following substantial question of law. The judgment and decree passed by the first appellate court against a dead person is a nullity in eye of law. When the appellant before the first appellate court in RA number 4 of 2009, namely Kenchappa, has died on 24/7/2016. Itself, before hearing of the appeal and before the judgment was rendered. Question: whether the courts below were justified in coming to the conclusion that the grant certificate Exhibit B2 issued by the Tahsildar Hiriur Taluk on 24/11/1964 in favor of Kenchappa son of Kariyappa alias Sanna Kariyappa, the father of dependents 3 to 5 and son of dependent number 1. Though the grant certificate exhibit P2 issued was in favor of the father of the plaintiff, Kenchappa, son of Kariyappa, and whether the document to evidence marked at exhibit P1 to P11 and exhibit D1 to D5 was not properly considered by the courts below. Admit, call for TCR, paper books within 4 weeks. Condone the delay.
Delay of 36 days.
Only 1 of 2017 is filed to condone the delay of 36 days in filing the appeal. Third, reasons indicated in the affidavit is accepted. Delay of 36 days is condoned. Accordingly, I1 of 2017 is hereby allowed. Yes.
And second, sir.
There is a
Divergent finding, proof for possession was filed by the plaintiff on the ground that there was an agreement of sale in favor of the defendant on 15/1/2001 as per exhibit P3, under which the defendant has agreed to purchase 6 cents of land from the plaintiff for a sum of rupees 20,000 within 6 months. When the defendant failed to perform this part of contract, a legal notice was issued asking him to purchase the property by paying the balance of consideration of rupees 19,000. And when he has not adhered that demand, the suit came to be filed for possession on the ground that before the agreement of sale, the defendant has erected a zinc sheet on the property of the plaintiff on the eastern side. Then the plaintiff has allowed the defendant to put up a compound wall on the property of the plaintiff covering about 6 cents. Since it was covered by the defendant on the property of the plaintiff, there was an agreement, exhibit P3, entered into between the parties so as to sell the property to the plaintiff. The exhibit P3 has been admitted by the defendant in his cross-examination, and there was no dispute to that effect. On the other hand, what the defendant says that the property comes within the boundary of the plaintiff, the defendant. Therefore, there was no delivery of possession by the plaintiff to defendant, and question of handing over the possession will not arise. And question of purchasing the property from the plaintiff also will not arise. That is the defense raised by the defendant. The trial court, by considering the admission of the defendant, decreed the suit. On an appeal by the defendant, the first appellate court has held that the delivery of possession has not been proved by the plaintiff. And therefore, instead of filing a suit for specific performance, the possession suit being filed. And after hearing the application filed by the plaintiff for appointment of commissioner, the appeal itself came to be allowed. As a matter of fact, the appellant and respondents were advanced the argument only on IA number 5 for appointment of commissioner, so as to measure the property, because the defendant possessed 39 cents of land, whereas the plaintiff possessed 44 cents of land. The property of the defendant stands 3 feet below, lower than the property of the plaintiff. However, he has encroached a portion by virtue of the permission, and therefore the suit came to be filed.
So according to you, this 6 cents of land is agreed to be purchased by the
defendant.
He admits exhibit P3.
Yes.
And after this agreement, according to him, he is not in possession. What is his contention?
Depends.
No, that is not
It is
in.
covered with the compound by the defendant.
So this 6 cents, according to him, falls within the plaintiff's property.
Yes, according to me, it is with the plaintiff's property. According to him, it is within the boundary.
No, is there something dividing?
Yes.
Is there
Yes.
something dividing the property?
Yes.
Then court commissioner was not appointed
Not
because.
appointed, I have filed an application before the first appellate court in this appeal, which came to be rejected. As a matter of fact, an argument on advance only on IA number 5.
Where is the reasoning of the first appellate court?
with respect to IA number 5, para number 25, page number 36. My God. 36. Page number 36, para number 25. The citation is squarely applicable to the present case on hand, therefore, on failure of the plaintiff to describe the property as described in the adjudication, namely agreement of sale exhibit is unacceptable one. Furthermore, in the plaintiff property, plaintiff has given boundary to the 6 cents of the property of plaintiff, which has been separated from the entire 44 cents of plaintiff, which has devolved upon the plaintiff as per exhibit 2 and exhibit 4. In fact, even to consider the existence of procedural property as treated by the plaintiff, even in the legal notice got issued by plaintiff dated 11/11/2003, exhibit P5, such a schedule has not been specified so as to consider that department has either utilized the premises of the plaintiff or for any reason for the beneficial enjoyment of the department has to be by the plaintiff. Under such circumstances, the application filed by the applicant does not survive the purview according to the number 5, which is as not mandatory. When exhibit P3 is not in dispute, 5 days may not be correct. Then, on merits of the case, the Lebanon First Appellate Court at para number 28, page number 41, point number 3.
Yes.
In the case on hand, as per the plaintiff prayer, the suit is for recovery of possession. However, as indicated by the plaintiff, the actual taking possession of the deponent of the plaintiff's property is not established. It is pertinent to note that plaintiff has not come up with the suit for present performance of the contract, but recovery of the property taken possession by the defendant. However, as indicated by Peter Gibbon in page number 4 dated 1871, makes it clear that at no point of time possession is delivered. It is based on the agreement of sale, possession is not delivered. That is my admission. Therefore, the issues raised by the trial court with regard to the suit relief and the facts pleaded are available. Hence, plaintiff is non-suited is for my permanent. Furthermore, as per the provisions of specific relief act, by making a plea of the plaintiff firm means pleading and also as to place cogent and substantial materials, it is pertinent to note as per exhibit E1 and admission of CW1 himself, that is defendant's property is lesser height to the property of the plaintiff. In the cross-examination of DW1, it has been made clear by getting elicited that property of the defendant is 3 feet lower than the plaintiff's property. Under such circumstances, plaintiff prayer that there is occupation of the plaintiff's property by the defendant becomes imagined. Furthermore, opposed to the DW1, they have removed the mud, agadu, and compound wall was against the case of the plaintiff. As a matter, this supports my contention.
What is the total extent of the property of the plaintiff and the
Plaintiff
total?
44 cents.
44 cents.
Defendant 39 cents.
4 cents and 39 cents.
39 cents.
And with what is that agreement exhibit?
Exhibit B3, 6 cents, with respect to 6 cents on the western side, eastern side of the plaintiff, defendant's property.
So after this agreement,
Yes.
was there any boundary being created?
There was no boundary fixed.
No boundary fixed after the agreement?
Yes.
No boundary. So according to you, the 6 cents
Yes.
is the property which is of the plaintiff.
Yes.
And the plaintiff, the defendant had agreed to purchase the 6 cents
Yes.
and he has
Yes.
now denied his.
Yes. Because he is allowed to put up a compound wall over and above 6 cents. And moreover, one admission, what the defendant DW1 says, compound in a ಒಳಗಡೆ 6
Agreement was to purchase the 6 cents.
cents.
So after purchase, he has included this 6 cents in his property.
Yes, yes, and put up a boundary. As allowed by the plaintiff. Plaintiff has allowed him to put up a boundary. Compound wall.
Now you have not seeking a right by way of that agreement. You are seeking a right by way of that agreement.
Possession, agreement only. Possession, I want my possession back. Because I allowed him to put up a boundary.
That is your plain government.
Yes. Moreover, the DW1 himself admits ಕಾಂಪೌಂಡ್ ಇನ ಒಳಗಡೆ 6-7 ಅಡಿ ತಗ್ಗು ಮಾಡಲಾಗಿದೆ. ಯಾವಾಗ ಮಾಡಿದ್ದು? ನಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಆದ ನಂತರ.
Where is that? That is the admission of DW1.
DW1. ಕಾಂಪೌಂಡ್ ಒಳಗಡೆ
Where are you reading?
ಮಾಡಲಾಗಿದೆ.
The evidence, huh?
ನಮಗೆ ಹಣದ ಅಭಾವ ಇರುವುದರಿಂದ ವ್ಯಾಜ್ಯದ ಸೊತ್ತನ್ನು ಅಳತೆ ಮಾಡಿಸಲಿಲ್ಲ.
there was an agreement entered between you and the plaintiff, correct? Correct? 6 cents of land, which was the agreement. You put up some compound wall after the agreement was entered. It is not your case that 6 cent was already in your possession before the agreement. So there is a compound wall. So after the compound wall has been done, now when you don't come forward to or purchase the property, rather he is not seeking for execution of the sale deed. What he wants is give back the possession in light of the agreement which has been entered, which is not disputed by the defendant.
Says that yes, that need to buy that 6 cents from our neighbor on the Excise. But after the execution of the agreement, the plaintiff started contending that the 6 cents of land is already part of my compound, which is where the dispute arose between the parties. We said that we might as well not go into the agreement with what the difference is. The difference is the plaintiff had a pre-existing dispute between himself and my vendor. The plaintiff had bought the land from the defendant. He had a existing dispute. Now, when we were putting up this compound, the offered that we buy the 6 but then when post execution of the agreement, the started questioning that the land you agreed to buy is already part of your holding. It is where the dispute arose that the
Total extent of your land is 39 cents. His is 44 cents. So 6 cents has to be with him or with you. Somebody has.
The contention is that possession was not handed alongside execution of the agreement. Agreement does not speak of handing over. What it is not that after the execution of the agreement, after some time, I permitted the difference. To also buy the 6 cents. That's what the song said. Yes, that will stand. Agreement doesn't speak of. Now, we're not saying that would be that way to be so much the plaintiff what to have entered the. Now, the permissive possession, but I would respectfully say, the question of permissive possession, something which is personal knowledge, does not enter. The sense is somewhat as far out of the order. It goes on. First question from my WhatsApp to consider what the legal said is worthy of. But secondly, perhaps while the suit was pending, but they had the opportunity perhaps of requesting the honorable to point in commission, fact-finding exercise, which could have perhaps cleared the air. That was not done. Now it was done related to perhaps to the honorable question. The application has been there. We have friend has questioned that part of the law. But question of law has been then
Then we will appoint a court commissioner here itself. We'll ask the ADLR to survey the land of the plaintiff and the defendant and see who is in possession of the 6 cents. So pending appeal, we will not admit the appeal. We'll ask the ADLR to conduct survey in respect of the plaintiffs and the defendant's property.
As a matter of fact, I have questioned the rejection of my IA also, point number 14.
Point number?
Ground number 14 in the appeal, page number 8. The lower appellate court has erred in law while rejecting the application seeking appointment of court. That the routine of property is therefore the lower appellate court failed to execute the evidence. So questioning the rejection of IA, I have raised the ground.
Which evidence? PW1 power of attorney. That would be your substantial question. Your substantial question. No, because it is the plaintiff's appeal now. He would never raise a contention that my power of attorney can be. So now. Yes, we will. Now, shall we admit this appeal or let us ask the ADLR to do the survey? So we'll ask the ADLR to suspend it. Plaintiff has approached this court in the regular second appeal against the judgment and decree in RA 28 of 2006, dismissing his suit and reversing the judgment and decree of the judge. Suit of the plaintiff is seeking for suit for possession in respect of 6 cents in survey number 166/1C, situated Alivur village at Udupi Taluk, at Udupi. The case of the plaintiff is that the defendant has agreed to purchase the suit property for a valuable consideration. The agreement was entered between the plaintiff and the defendant on 15/1/2001. The agreement entered is not disputed by the defendant. The plaintiff contends that in survey number 166/1C2, measuring 64 cents, lying on the eastern side is the property of the is to the western side, right?
Yes.
Eastern side is his. Eastern side is the property of the plaintiff. And to the western side, measuring 39 cents, is the property of the temple defendants. The dispute is regarding the 6 cents, which according to the plaintiff, the defendant has agreed to purchase the property. The plaintiff filed an application before the first appellate court, seeking to appoint a court commissioner to measure the property of the plaintiff as well as the same was rejected by the trial court, by the first appellate. The appellant plaintiff has raised, is aggrieved by the rejection of the application seeking appointment of court commissioner as well. In the circumstances, this court feels it appropriate to appoint the ADLR, of which would be
It is Alivur village, Udupi Taluk.
at village in of Alivur village of Udupi Taluka to measure the property of the plaintiff and the defendant and file a report to the court. The commission work by the ADLR to be conducted on or before 15 days. One date for it. Can he do it, Mr. You have to communicate this order to your ADLR. Can he do it by next week? Vacation ಅವ್ರಿಗೆ ಇರೋದಿಲ್ಲಲ್ಲ. On 14th ಅಂತ ಹಾಕೋಣ. 14 on 14. On 14. 14. The plaintiff and the appellant and the defendant to submit a representation to the ADLR and bring to the notice of the ADLR the order passed by this court. Communicate. And the SCGP so to communicate the order to the ADLR. The ADLR to submit his report on or before after this 1 day's period. 22/10. Yeah, the appellant and the respondent to submit the memo instruction to the ADLR on or before 14th October 2020.
Number 13, deal with the LG.
Partition and in respect of national properties. Declaration in respect of national properties were declared in entire. The plaintiffs are the children to the second wife.
You are the plaintiff or the defendant?
Plaintiffs,
You are the plaintiff from the first wife or the second?
second wife, second.
Second. Yes.
Now that the law is settled. and
Devana
also-
Siddhappa.
And in view of the fact that the father or fourth defendant has died during the pendency of this appeal. Now that they have been attacked for the equal share.
Equal share in a. You have to go as a notional.
Notional.
One share to the father.
But what's happened is, the father has succeeded to the ancestral property. Therefore, it becomes a self-acquired property.
And the children are there, it doesn't become self-acquired property, but it
But
becomes,
it's
take
not
the
clear.
character,
And
take the character of the joint family.
the said partition is during the, after the birth of the children or earlier is not.
See now,
Clear.
if you are the second wife children during the subsistence of the first marriage, then you are entitled for notional partition, that is one
Father
share,
share.
father share.
Father share.
So what share the father would have, you would be entitled. That is, first father would have one share, 1, 2, 3, 4, and 5, 1/5 share. In 1/5 share, you will be having 1, 2, 3, 4, 5, 6,
1/30th or 1/30th.
1/30th share.
But here, Madam, there's no clarity as to whether the said partition has taken place
Ultimately, now you would be at least getting 1/30th share.
on the
What did the trial court do?
trial court declared the suit in entirety. In
One
respect
seven
of
share.
national property, they have not challenged the said finding.
They have
Usually-
given you equal share,
That has been set aside by the first appellate court.
rightly, Alva.
By confirming the finding with regard to B schedule property.
Why we
B
schedule?
schedule property is through a will executed by a grandmother. That's not disputed by them.
That is not it.
That's not disputed.
That
They
has
are not
been-
challenged the said finding.
You have been entitled, you are entitled for
For
notional
the entire
partition.
petition.
What is the substantial question of now? Notice has to go.
That point of time.
Hmm.
In view of the conflicting judgments, the Revan Siddhappa's case was also pending consideration. And the only substantial question of law that I had raised was, in view of the said situation, the lower appellate
So we
court
will
also-
frame this substantial question of now, that is whether the first appellate court was justified in reversing the judgment of the trial court and dismissing the suit of the plaintiff by, and whether the plaintiff would be entitled for share in light of the judgment of the appellate court in the case of Revan Siddhappa. Okay. The plaintiffs are before this court, the regular second appeal against the judgment and decree of the first appellate court, dismissing, modifying the judgment and decree of the trial court and dismissing the suit of the plaintiff in respect of plaint A schedule, plaint A, inverted comma, scheduled property. The plaintiffs are children of H.T. Ramaya through his second wife, Hanumamma, and learned counsel for the appellant submits that the plaintiffs are entitled for share in the share that would be allotted to the father. The matter requires consideration. The appeal is admitted to hear the following substantial question. Whether the first appellate court was justified in holding that the plaintiffs are not entitled to claim share. Question mark. And next question, whether the plaintiffs are entitled for share in the suit A properties in light of the judgment of the apex court in the case of Revana Siddhappa. Admit, call for TCR, paper book dispensary. The appellant has filed memo for retirement along with the acknowledgement stating an acknowledgement stating that the appellant has taken the entire case to papers. The memo of retirement is taken on record. Appellant counsel is permitted to retire from the case. Registry to delete the name of the appellant from the list. Issued court notice to the appellant returnable by is that connected up? Who has filed that?
Respondent is a common ballot, but appellant sounds, I have only filed.
Why two appeals?
Two different parties, two different properties.
Yeah, what was the suit for?
Should was declaration and formal rejection. That,
You are the plaintiff,
no, I am the defendant.
defendant.
Defendant will not right by virtue of the proper sort of court. And by virtue of a joint memo, the property for the allotted to be. Defendant, the plaintiff will be to the trial court, and right a suit for declaration and for possession. The trial court confirms dismisses the suit as far as the title is concerned, and as far as the permanent position is concerned, he grants a decree stating that his position is false. The High Court judge
No, in that compromise, whether this plaintiff was a party,
was not a part of the vendor, vendor was a part.
vendor was a party.
Father also, mother, I also, this was the honorable court.
No, their suit is for declaration and permanent injunction. Declaration for what? Declaration
That is the owner of the property.
based on
Yes, other said and executed by one Venkatappa, appears. Later on, the property is now, the tendency of the second appeal before the honorable court, that property can be.
when was this held? When was this held? Okay. See, if the sale deed is prior to the compromise, then his vendor, the plaintiff's vendor was aware that there is a sale deed in favor of the
He should
plaintiff.
not have entered into a compromise. Now what has happened, my lord, he has speaker me and speaker the waiting for.
So that compromise has no implications to the present plaintiff here, correct?
As far as the title is concerned, my lord,
Title, when he has already sold the property to a third party, what title he had over that property?
The property, my lord, that the same, my lord, is, and told that he told to the business here, honestly. Therefore, my lord, that's a difficult offer.
When was RSA disposed of? Adheli. That is why this court asked you, when was the sale deed and when was the compromise entered?
Okay. I'm putting the copy.
What copy you have?
Transport order copy.
ಇದರಲ್ಲಿ ಇರ್ತದಲ್ಲ records.
That's it.
All for PCR. Okay.
Also, along with the connected RSA,
What is that? What is that second appeal about?
that is about my lord, the other person who is also claiming right over the person, my lord.
Was it arising out of any
Same
suit?
document.
It was arising out of the same suit. Suit.
Properties are different.
No, let us see. ಅದು ನೋಡ್ ಮಾಡೋಣ.
Can also claim right, my lord, and this is
Next.
Case number 16, with Siddharth Chicham.
Yes, your colleague says we have not. No, we don't want sorry, but then there should be something there. It's very unfair to say that we have not heard. Yes. Your right is very limited. Yes. But then, look at it.
Two courts must have wrongly read the.
Ah. So both the courts should at least know what is it. On assumption they go. So the appeal has to be allowed. What to do?
I know that process is going to follow.
Hmm.
Yes, but the experts are possible.
If you are willing to explore, you are always at liberty to explore. Is it not? And this should have been done by now, Vada. No, if you are willing to explore some possibility, what is that exploring would be? You have to save your property, rather give back the property and take back the money what you have been given to the other dependent number one. Is what you propose. No, if they are, let them take a chance. They should not feel that we have not afforded an opportunity. Ultimately, we are going to pass an order. Now he has already invested. On what basis he has purchased the property, we don't know. By Monday. Monday for dictation. This court will resume after 10 minutes. They are in the midst of the list, right? We are in the midst of the list now. Yes. Which is that you are mentioning? 40? 40? Deshwaz. He mentioned that he is in the. But like Appellate Council mentioned it in the morning. You were there, right? Yes, you inform the appellant to be present. Call the appellant counsel.
Getting judgment number 17, please sound as ready.
In that sort, the defendant number, that is defendant number 4, he contended that it is the exclusive property of Nagappa in his written statement. He contended that it is his exclusive property. And the court held, no, he had some legal necessity. So he is a bona fide purchase.
Saying that he is not exclusive owner, there are shares.
So there is a contrary. Kindly be seated. Against the concurrent findings of facts recorded by the courts below, the defendant, number 2, purchaser, is before this court in the regular second appeal. The parties herein are referred to as per the rank before the trial court for the sake of convenience. Suit seeking for specific performance of contract of agreement of sale dated 26/5/2005, directing the defendant number 1 to execute the register sale deed in his to execute the register sale deed and to declare the sale deed dated 9/1/2007 executed by the defendant number 1 in favor of the defendant number 2. This defendant number 2 is null and void and not binding on the plaintiff. The plaintiff was that defendant number 1, the plaintiff and defendant number 1. Plaintiff was the defendant number 1 agreed, entered into an agreement of sale dated 26/5/2005 in respect of the suit property for valuable consideration of rupees 1,62,500. And on the date of the agreement, defendant number 1 has received an advance as sale received the earnest money of rupees 1,20,000 and agreed to receive the balance sale consideration of rupees 42,500 at the time of execution of the sale deed. The agreement stipulated the time of 18 months or whenever the plaintiff intimates his readiness and willingness to pay the balance sale consideration amount. It is the case of the plaintiff that the defendant number 1 evaded the execution of the sale deed on one pretext or the other. and the plaintiff issued a legal notice to defendant number 1 on 12/9/2006. Directing the defendant number 1 to come forward to execute the sale deed in his favor. The notice was served on the defendant number 1 on 16/9/2006. The defendant number 1 did not reply to the said notice. And subsequently, the defendant number 1, during the pendency of the suit, has sold the suit property in favor of defendant number 2 to a registered sale deed dated 9/1/2007. It is stated that the defendant number 2, in spite of having knowledge about the earlier agreement of sale dated 26/5/2005 in favor of the plaintiff, has purchased the property, and the sale in favor of defendant number 2 is null and void. Next. On notice, the defendant number 1 appeared and filed his written statement, inter alia contending that the suit property originally belonged to Subarna, who had 3 sons, namely Chikka Venkatappa, Muni Venkatappa, and Chikka Chikkala, and Muni Swamappa, Munswama, and that Chik Venkatappa had 2 sons, Venkateshappa and Nagappa, defendant number 1. And Muni Venkatappa had a son and 5 daughters, and Muni Swamappa is having a daughter by name Bhagyamma. The defendant number 1 contended that the suit property is the joint family property of the sons of Subarna, and there is no partition effect. It is contended that the son of Chikka Muni Venkatappa, had filed a suit seeking partition against defendant number 1 and other sharers, which includes the suit property. Further, that the suit property is not convenient for division among the sharers, and as such, they had decided to sell the suit property for valuable consideration in favor of defendant number 2, and the possession has been delivered to the possession of the property has been delivered in favor of defendant number 2. The defendant number 1 contended that the agreement of sale dated 26/5/2005 is created by forging the signature of defendant number 1. Defendant number 2, the purchaser of the property during the pendency of the suit, filed written statement contending that the suit property is the absolute property of Nagappa, and the khata of the property stands in his name. And Nagappa, along with his son, as sureties, have sold the said property in favor of defendant number 2 for valuable consideration to a registered sale deed in his favor on 9/1/2007. And the defendant number 2 is in possession of this. The defendant number 2 contended that plaintiff and defendant number 1 have colluded and have created the agreement of sale. The defendant number 2 contended that he is a bona fide purchaser of the suit. The trial court, on basis of the pleadings, framed the following issues. Page the trial court, considering the oral and documentary evidence, arrived at a conclusion that the plaintiff has proved the agreement of sale executed by defendant number one and two, that the defendant number two failed to prove that defendant number one along with his son has in his favor for valuable consideration. And by the judgment and decreed the suit of the plaintiff, directing the defendants one and two to execute the sale deed in favor of the plaintiff and put the plaintiff in possession of the suit property. Agreed. The defendants preferred appeal before the first appellate court. The first appellate court, while reconsidering and reappreciating the entire oral and documentary evidence, concurred with the judgment and decree of the trial court. Aggrieved, the defendant number two has approached this court, the regular session. Third, then its senior counsel for the appellant and then it counsel so for the respondent by the same. When its senior counsel would submit, then its senior counsel submits that the respondent reports below findings regarding the execution, genuineness and the contents of the sale agreement, Exhibit P1, is perverse and contrary to the evidence on record. That the courts below have failed to consider that the agreement, Exhibit P1, is invalid and legally unenforceable, as the suit property was the ancestral property of the defendant number one, and the defendant number one had no competence to enter into an agreement of sale of the suit property with the plaintiff. Then next, that in OS number 579 of 2007, filed by Shardamma and others, children of Chikka Venkatappa and children of Nagappa, for partition and separate possession, the concerned court has arrived at a conclusion that the defendant number two is a bona fide purchaser of the suit property in light of the sale deed executed by Nagappa in his favor, and would contend that the defendant number two has to be held to be a bona fide purchaser, having purchased the suit property on 9/1/2007 for valuable consideration, and in light of the finding recorded in OS number 579 of 2007. For contrast, the learned counsel appearing for the respondent justifying the judgment and decree of the trial court. Judgment and decree of the courts below would contain that the courts below have exercised the discretion under section 20 of the Specific Relief Act and held that the agreement exhibit P1 is proved by the plaintiff and the plaintiff is entitled for specific performance. That the defendant number 2 is not a bona fide purchaser as the suit property has been purchased during the pendency of the suit and the sale is hit by section 52 of the transfer of property. Next. That the defendants 1 and 2 were aware about the pendency of the suit in light of the legal notice which was issued to the defendant number 1 dated 12/9/2006 and after the acknowledgement of the legal notice, the sale deed has been executed in favor of the defendant number 2 on 9/1/2007 during the pendency of this. And the defendant number 2 is not entitled for any relief from the hands of this court. That the concurrent findings or facts recorded by the courts below does not warrant any interference under section 100 CPC. This court has carefully considered the rival contentions urged by the learned counsel for the party and perused the material on record. The relief of specific performance is in respect of the suit property as per the agreement entered on (26/5/2005), Exhibit P1. Plaintiff examined himself as PW1 and contended that there is an agreement executed by defendant number 1 and his children in respect of the suit property. PW1 was cross-examined by the defendant number 1. Nothing worthwhile is elicited from the cross-examination of the PW1 to disbelieve his contention. The plaintiff examined the one witness, examined the witness to exhibit P1 as PW2, who categorically stated about the execution of the agreement and the sale consideration of and part sale consideration of rupees 1,20,000 being paid to the first respondent. PW3, the scribe of exhibit P1, was examined by the plaintiff. PW3 evidence stands in line with PW2. The counsel for the defendant number 1 examined cross-examine PW1 and PW3. Nothing worthwhile was elicited from the cross-examination of PW2 and PW3 to disbelieve the version of the witness and the scribe. On the other hand, the defendant, number one, examined himself as DW1. The DW1 disputed his signature on Exhibit P1 and also took up a contention that the suit property is the joint family property of Chikkaventappa and Chikkaventappa. DW1 deposed that the suit property has been sold to defendant number one, defendant number two for sale consideration. One material aspect that needs to be considered here is that the children of Chikkaventappa and defendant number one, Nagappa, instituted a suit in OS number 579 of 2007 after the present suit was instituted for specific performance of contract. The said suit came to be decreed and defendant number one and two were arrayed as party to the proceedings. Neither the defendant number three nor the defendants, the present defendants who were arrayed as defendant number 3 and 4 in the said suit, brought to the notice of the court about the pendency of the present suit for specific performance. And in the said suit, the defendant number 4, defendant number 2 herein, bracket money, contended that he is a bona fide purchaser, having purchased the property from Nagappa for the joint family necessity. And the trial court, the consent court, in the said circumstances, held that he is a bona fide purchaser. Bona fide purchaser. The plaintiff was not party to the said proceedings. And neither it was brought to the notice of the court about the purchase of the property during the pendency of the present. One material aspect that needs to be considered here is that before instituting the present suit by the plaintiff issued a notice, legal notice, to the defendant number 1, marked at Exhibit P4 on 12/9/2006. Postal acknowledgement for having served the legal notice on the defendant number 1 is produced as Exhibit P9. Defendant number 1 after knowing about the plaintiff to file a suit for specific performance, has entered by way of a sale deed, has executed a sale deed in favor of defendant number 2 on 9/1/2007. After the institution of the suit. The suit, the sale deed is executed during the pendency and hit by section 52 of the Transfer of Property Act. The defendant, number 2, has failed to prove that he is a bona fide purchaser of the suit property. And moreover, the trial court had granted an ex parte temporary injunction order on 6/12/2006, restraining the defendant number 1 from alienating the suit property. And on 6/2/2007, the temporary injunction order has been extended until further orders, and this defendant number 2 has purchased the suit property from defendant number 1 on 9/1/2007 during when the temporary injunction was in force. The contention of the learned senior counsel for the appellant that the defendants were unaware about the institution of the suit is unacceptable in light of the legal notice being served upon them, upon defendant number 1. The law is well settled that once an interim order is granted by the court, it partakes the character of restraining the opposite party from doing any action. Mere non-communication or mere non-communication of the interim order on defendant on the other party would not make the interim order passed by the court sub judice. And this, the defendant number 2, having purchased the property during dependency of the suit, cannot claim to be a bona fide purchaser of the suit property. In OS number 579 of 2007, the plaintiff was not a party, and the judgment passed in OS 579 and the findings in OS number 579 of 2007 was without bringing to the notice of the court about the purchase made by the defendant number 2 during the pendency of the suit. The perusal of the judgment and decree of the court below. This court is of the considered view that the manner in which the court below have assessed and exercised its discretion of granting specific performance of contract in favor of the plaintiff. This court is of the considered view that the same does not warrant any interference, and this court passed the following note. The regular second appeal is hereby no substantial question of power at this point. The court passed the following note. Regular second appeal is hereby dismissed. The judgment and decree of the court below stand. No further questions. Yes.
In the plan that they give to us, we have excellent. Only where they are giving is something will go tomorrow. Whether they show the property which they are giving it. Whether we draw the sketch accordingly.
So there is possibility of settlement now.
Already given it two items. Does we request for
Whatever, if they are agreeable, they are agreeable to that.
I am agreed for that house.
One gunta is separate they will give it. I said there is two guntas.
ಒಂದೇ ಕಡೆ ಕೊಡಿ, you can solve all the dispute of one. What do you want?
Any day.
To report settle, both the counsel submit that there is a possibility of settlement, and the same would be reported to the court on next date of hearing. Is this matter on 24th for reporting to court? Yes, Mr. Mohan Kumar. Oh. Okay.
Really possible, right?
You were arguing, right?
First case, that's 292. So, it's a division findings. That I was I complete that. Very fast. Because I am an appellate in my learning.
Oh, yes. The two appeals. One is by defendant, RSA 292 of 2016.
If they say the defendant, as I can say, diversion findings.
Suit for partition dismissed. Appellate court decreed in part, except in item number 4 to 4, 10 to 12. So defendant's appeal insofar as decreeing the suit. Is it not? And insofar as non-decreeing of your suit, they are before.
Their appeal is concurrent findings, my appeal.
Ultimately, whether you are entitled or not, that has to be looked. Whether they are entitled to or not. So item number 4, 10 to 12 is rejected.
Yes.
Item number 4, 10 to 12. So what is granted is 1, 2, 3. Ashena?
3, 5 to 9.
5 to 9.
13 to 16.
Okay. Granted. Allotted. What is the share granted? What is the genealogy? Got any genealogy here? Here it is there. Patel Shinge Gowda was defendant number 1, and his wife is Lakshmama. Then is Jai Kumari, second wife. Defendant number 8 is the Jai Kumari, and Shushila is the daughter of Lakshmama through first wife. And the defendants 2 to 7 are children of defendant number 8.
4 and 1 Mamta minor Patel Singh through Jay Kumar.
Correct.
That
Defendant
Mamta minor was no more. And hence, her husband by name Ganesh has been added as
so 2 to 7 are the children of defendant number 8.
4 are the children of defendant number 8. Jay Kumari and Patel Singh had another daughter by name Mamta. No more.
So his her
Husband and children are added as defendant number 8.
ultimately all are the branch of this Jai Kumari. On what ground the suit was dismissed?
That the property that Patel Singh not from his ancestors. Now the Grand Court says that since he has inherited it, he becomes a sharer of this property as a class 1 heir. And during his lifetime, Sushila cannot maintain a suit. Simply ground on this. The Court is now married to you. Now, admittedly, his the properties.
What does Uttam Singh says? What does Uttam say?
Reservations that is there to create a co-partner. How the way in which this property have come to it, from the father of Patel Singh. From this lifetime, there is a partition among Patel Singh and this brother. Property has fallen to the share of Patel Singh.
So if at all a property falls in a partition and in the hands of the children of Patel Singh Goda, it becomes the joint family property is your contention.
Now, what happens now is on this ground, one of the transport business is placed. I go on in the field. Now, if you go back, that the marriage of Patel Singh with Kumar was during the lifetime of Rajkumar. The entire branch of Jay Kumari Malad are the illegitimate children of Patel Singh. So, invoking Malad Revan Siddhartha's case. Sheila is a legitimate daughter, becomes a co-partner. Along with Patel Singh Goda dependent number 1, she gets half share.
Correct, half and half.
Half and half.
So half, in that half of Patel Singh Gowda, the not the wife, the children, that is dependent number 2 to 4 and one branch of Mamta.
Yes.
So 1, 2, 3 and 4. And in 1/4, 1/8 share.
Sheila Malad give.
Yes, yeah. 1/8, 1/10 share. So 1/10 share would be the share that would be entitled by the defendant's branch.
After the demise of Patel Singh, Patel Singh is there.
Patel Singh Goda is not alive, right?
As of today, half and half Malad is the. Now, my grievance is that when the properties are admittedly the admittedly, I use this word because of the cross examination I am able to miss completely that these properties which are subject matter are all the ancestors. Patel Singh Goda has got a commission to examine the deal with them. There are admissions to this. Even in his written statement, he did not specifically say which are the self-covered properties as joint family. Only said there are certain properties which are joint family properties, there are certain properties. I don't have any objection for granting the share in respect to the joint family property. But as far as my self-covered property is mine, only written statement. Now, in that light of the matter, 4 properties have been disputed from the purview of the degree. Now, the reason is item number 4, my lord, she came to have purchased the property. Item number 4 is in the year 1970, claims to have purchased the property. 1970. He claims to purchase item number 4. That is survey number 44/5. Now, 300 is the consideration paid.
What was his avocation?
In the return statement, he doesn't say anything. What was the source of income for him to purchase the property? In his cross examination, he says except agriculture, he did not have. Thereafter, improvisation is sort of made. He was building some tank and but that only comes into evidence. But as far as the reading is concerned, avocation to show that he had got an independent source of income to acquire the property. This is item number 4. But likewise, my lord, there is item number.
What was the evidence placed by you to show that this family had sufficient income from the ancestral properties to purchase this property?
So I have now the extent of land is my lord in the most totally, my lord, 9 acres of land, my lord, is available.
Excluding this item number 4,
No,
10.
including.
No, excluding the
Excluding it, my lord, is 4 acres, 27 acres.
4 acres, 27 guntas.
Yes.
And agriculture, what was it produced from this lands? You have stated in your evidence. And he was not doing anything apart from.
Anything apart from.
He had any other agricultural land which he had purchased? Yes, next.
But as far as item number 11 is concerned, he says that he has purchased it on 26/3/1970. This exhibit key. The consideration again is 300 rupees. On 26/3/1970. That is also for some of these. That measures minus 22 gutas. That is about 2 lands which has got it. Item number 10 and 12 minor, he sets up a grant.
Grant.
Grant. As far as item number 10 is concerned, grant certificate is not.
And in favor of defendant number 1. What you say regarding this item number 10 and 1, 10 and 12?
My contention that we can call this as.
Now when this property, that is a grant, is there in favor of defendant number 1. It is some material to show that your father was his grandfather, that is Patel's Shinge Gowda's father, or anybody was granted this land. What happens then?
Like now, he has come up with a specific defense that he said was granted to the end.
Okay.
These things that I expect from you is so at least produce the concept. Why I am making this submission? Regarding item number 12, he produces the concept. Something important minus comes out. What is that important here? The grant has taken place legally. Now, very interestingly, Patel Singh Gowda's father name is also Patel Singh. Now, at 1946 is when Patel Singh Gowda was born. That is defendant number 1.
Yes.
The grant minor has taken place in the year 1952. Grant is known as Patel Singh Gowda.
Only in respect of item number 12.
Item number 12.
Favor of Patel Shinge Gowda.
Yes.
Yes.
So, those claims of a grant, because it was that the grant because he was only 6 years old by the time when this grant was made.
One question regarding item number 10. What was the averment in his written statement about the grant in his favor? When was the grant in his favor, at least?
The plan was made. Totally silent in his reading level.
How can a father's name and son's name be same?
His partner.
Hello, father and son's name. It cannot be. During the lifetime of his father, whether the father would keep the name of his own to his son also, it would be grandfather, Allah. It's very unlikely.
This is part of the.
Allah, see, question is, Narsimha andre, father is Narsimha. During his lifetime, will he keep his own name to his son?
To his grandson.
It would be to his grandson, right? Then when somebody calls somebody, the father will come or the son will come? It's very unlikely. Patil Shinge would be a surname. It is a surname. Gowda is also a surname. So what is his name? Patil Shinge Gowda. 3 surnames here. Shinge also cannot be a name. It is for the family, you have to say. Yes.
The grant in exhibit D3 could not be dependent number 1 at all. Because a 6-year-old child could not take it. And it is why he does not want to produce the grant certificate consistent.
How did the trial first appellate court go on this aspect? What is the substantial question of law in this law?
It's not admitted. Something not agree that the lordship has to raise the question of law in this appeal.
In which
And when I
appeal?
has to address them.
At the stage of admission only we'll consider this, whether it is necessary to claim substantial. Regarding second,
Not because admitting, because I have to frame the, not an opportunity.
second appeal is by him insofar as non-granting of 4 to 12. Both the courts, on what ground they reject their prayer in respect of item number 3 and other property. What is the ground? For what reasons they reject
The
here?
trial court dismisses because the right has not yet fructified in my favor, because Indian order will
So
bring
now
the
we have to
property.
see as to what happens, what is his right in light of a partition effected between his brothers that would be the character of the self-acquisition or a joint family property. So you have to place those two decisions wherein Vinita Sharma is in light of not in this context. It is only that Uttam Singh case you have to place. What does it say? Kindly furnish the judgment. Uttam Saubhagya. Uttam Saubhagya judgment. No. Ask her law officer. Law clerk. You have produced that judgment.
Right, the deposition.
Versus. 8,000.
Imposition of leadership, because that manner would clear majority of the factual.
Their entitlement of the children born through the second wife is only after the death of the father. In the event it is the self-acquired property. And if it is a joint family property, to the extent of the share that the father is entitled. That's all. Now, what would be the nature of the suit property once it devolves upon him in a partition suit? To the children, then what would be the nature of acquisition to the children of the said? Yes, now we have to state regarding that proposition of law.
On fact,
No, and we are clear with the facts now. You have to say about this proposition. Both of you all have to assist this court regarding that. He's already completed. Facts are over. Now the law. Really?
So as my lord, the joint family is concerned, Lord, according to my lord, the dependents, these properties, my lord, are self-acquired properties.
Then self-acquired properties, how do you establish that it is your self-acquired properties? Only by way of purchase. You have to show sufficient income for you to purchase the property individually.
Lord shifts, but on shifts only recipe and evidence. Here, kindly see the line there. So there is no bidding. So this is
The suit is simple suit for partition, saying that my father has got this property in a partition, one part. Another, he says this property are the joint family properties of the plaintiff and the dependent, though it is purchased in the name of the dependent number 1, it doesn't partake the character of self-acquired property of dependent number 1 because he had no independent source of income.
It's not a bidding. There's not a bidding. They say only all these properties are assets. Let me see the line there. That's not correct. What my amendment said, bidding, they never said it's a joint family property and it is purchased out of the family fund or no place.
What did they say?
Let me see the plaintiff. They never say the plaintiff.
Plaintiff.
Amended plaintiff. Record.
If you read the plaintiff.
The plaintiff is the daughter of first defendant. The first defendant has bought the and second wife taken away. The first wife Lakshmana is lifetime of first wife Lakshmana, the first defendant has got married to Jay. Out of wedlock of the first wife Lakshmana, that the plaintiff was born to the second wife, Jaikumari, that the decree number 2 and 4, other daughter by name Mamata was born. They said Mamata died leaving behind her husband, the decree number 5, and her children was the decree number 6, 7 in. The social properties are ancestral and joint family properties of the plaintiff and defendants. The plaintiff and defendant are joint.
Just a moment, just a moment. Just a moment. In this Uttam's case, this grandson had expired. The grandson was born after the death of the grandfather. So in that circumstances, it was there. Yes.
There are three legitimate properties. There are three of the
Yes.
The future properties are ancestral and joint family properties of the plaintiff and the defendants. The plaintiff and defendants are looking joint and enjoyment of this. The defendant number 1 is a manager of the joint family. The defendant number 1 has completely neglected the welfare of the plaintiff. The defendant number 1 is not managing the joint family property. And has addicted to all sorts of bad habits and such as drinking, gambling, and wasting the income of the.
That para number 3, they say defendant number 1 is the manager of the joint family. Andre,
It's not clear. That's not particular.
in a partition suit, he need not seek anything. He has to just seek for a partition and his entitlement of share.
As far as self-proclaimed properties, the properties are purchased and granted. They will say that this
Burden is always on you to say that it is self.
burden was not fixed.
Initial burden, correct. Initial burden is on the plaintiff or say that it is a joint family property.
Family property and purchase the same out of the joint income. That reading is not there. You must say this is the property item number 11 at 12. It is purchased out of the income which arrived from the joint family. So that reading is not there.
Yes.
And as far as grant also is concerned, the grant is made in favor of the family. Reading is also there. But there is no presumption with respect to Tarka's land, the granted land, so that it belongs to joint family unless there is pleading, evidence,
and my lord, two. Government document. So all these, my lord, pleadings, my lord, are not there, my lord, in the claims. Therefore, the question of burden on the, my lord, the victim does not arise. There is no pleading at all. Simply they say all the 16 properties are ancestral and joint family property. They cannot be as per para 3 of the claim. She born in 1982. She cannot be in a joint possession. Both are cultivating.
That is something, no daughter would be in possession of the property.
But these properties were acquired in 1970s. She cannot say that I was cultivating and I was in joint family property. It's not the case where, my lord, the senior brother or sisters have filed the case. It's not that kind of case. If at all the brother or sisters have filed the case, my lord, these pleadings.
Correct. Shinge Gowda's brothers and sisters need not come because your contention is Shinge Gowda is the absolute owner of this property and he was being given share in the property. He has been granted land. It has been granted.
Properties. I say, my lord, some properties are ancestral properties.
Did you specify which are the
I not
properties?
they have not said
That's
anything.
why the courts
They say-
also went in that assumption.
They say that all the properties are joint family properties. Lord, based on the evidence, my lord, accused. Based on the
When a
documents-
particular person says in his written statement that a particular property is not the joint family property, he has to specify which is the property, not the joint
You say-
family. Which are the properties? Did you say in your written statement, these are the properties which were granted to you? Is the plaintiff who is not residing in the, along with the brothers, they are unaware as to so many things, as to whether it is,
Not the case of the daughter, yes, by the.
correct, sir, daughter of Shinge Gowda, right?
They don't follow. See, my lord, Lakshmaya.
Ah, that is all settled.
There must be a pleading. There is no pleading, there is no question of the being further. For a 17 of the judgment really. In view of the aforesaid discussion, the respondents are failed to discharge the initial burden, establishing that there was a nucleus in the form of any income. That's what we lot of
Evidence has to be there to that effect. Everything, evidence, documents cannot be there in the plaint. Plaint is to be a formal plaint and it is the intelligence of the advocate not specifying everything in the plaint.
So not being melodic and elaborate, at least they must say these are the properties.
He says, he has come to the court saying that this is the ancestral joint family properties. Then he leads evidence, these are the properties which was yielding so much of income. And from the income, this is the properties which has been purchased.
No evidence also. No evidence. In the evidence, she does not say anything. Then not only the client, not only the client, I will read the evidence.
No, this judgment is settled. We need not.
Certainly, subsequent judgment also.
Come to the evidence directly.
He never said that there was out of a family income, then family income, he has purchased the property. He never said.
Yes.
Cause of middle.
Evidence होते.
ಹೌದು ಎವಿಡೆನ್ಸ್ ನಾನು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮಗಳಾಗಿರ್ತೇನೆ. ನನ್ನ ತಂದೆ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಇಬ್ಬರು ಹೆಂಡತಿಯರಿದ್ದರು. ಮೊದಲನೇ ಹೆಂಡತಿ ನನ್ನ ತಾಯಿ ಲಕ್ಷ್ಮಮ್ಮ, ಎರಡನೆಯವರು ಈ ಪ್ರಕರಣ 8ನೇ ಪ್ರತಿವಾದ ಏಕಮರೆಯಾಗಿರುತ್ತಾರೆ. ನನ್ನ ತಂದೆ ಪಟೇಲ್ ಸಿಂಗೇಗೌಡ, ನಾನು ಲಕ್ಷ್ಮಮ್ಮ ಜೀವಂತವಾಗಿರಲು 8ನೇ ಪ್ರತಿವಾದಿ ಎರಡನೇ ಮದುವೆಯಾಗಿರುತ್ತಾರೆ. ನನ್ನ ತಾಯಿ ಲಕ್ಷ್ಮಮ್ಮನಿಗೆ ನಾನು ಒಬ್ಬಳೇ ಮಗಳಿದ್ದು ಬೇರೆ ಯಾವ ಸಂಬಂಧ. ಈ ಪ್ರಕರಣದ 2ರಿಂದ 3 ಪ್ರತಿವಾದಿಗಳಾದ ಅಶ್ವಥ್, ಧನಂಜಯ, ಸ್ವಾಮಿ, ಮನ್ಸು ಹಾಗೂ ಮಮತಾ ಎಂಬ ಮಗಳು ನನ್ನ ತಂದೆಯ 2ನೇ ಹೆಂಡತಿ ಜಯಕುಮಾರಿ ಮೂಲಕ ಜನಿಸಿದ್ದಾರೆ. ಮೇಲ್ಕಂಡ ಮಮತಾ ಮುಕ್ತವಾಗಿದ್ದು ಪ್ರಕರಣದಲ್ಲಿ 5ರಿಂದ 7 ವರೆಗೂ ತನ್ನ ವಯಸ್ಸುಗಾರರನ್ನು ಬಿಟ್ಟು ಹೋಗಿತ್ತು. ಸೊ ಪ್ರತಿವಾದಿಗಳು 5ರ ಮಮತಾರವರ ಗಂಡನಾಗಿದ್ದು ಪ್ರತಿವಾದಿ 6 ಮತ್ತು 7 ಮಮತ ಮತ್ತು ಇದ್ದಾರೆ. ಈ ಪ್ರಕರಣದ ದಾವಸಂತಗಳು ನನ್ನ ತಂದೆಯ ಪ್ರತಿವಾದಿ 1ರಿಂದ 7ರವರೆಗೂ ಒಟ್ಟು ಆಸೆಯಾಗಿರುತ್ತದೆ. ನಾವು ದಾವಸಂತಗಳನ್ನು ಬೆಂಕಿಯಾಗಿ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತೇವೆ. ಮೊದಲನೇ ಪ್ರತಿವಾದಿ ತಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬದ ಯಜಮಾನರಾಗಿರುತ್ತಾರೆ. ಮೊದಲ ಪ್ರತಿವಾದಿ ಒಟ್ಟು ಕುಟುಂಬದ ಪ್ರಕರಣದಲ್ಲಿ ಸರಿಯಾಗಿ ನೋಡಿಕೊಳ್ಳದೆ ಮದ್ಯಪಾನ ಮತ್ತು ಜೂಜುದಾಸನಾಗಿದ್ದು ಜೂಜಾಟ ಒಟ್ಟು ಕುಟುಂಬದ ಆದಾಯವನ್ನು ಪೂರ್ವ ಮಾಡುತ್ತಾ ಇದು ನನ್ನ ಯೋಗಕ್ಷೇಮವನ್ನು ನೋಡದೆ ನನ್ನ ಸಂಪೂರ್ಣ ಜೀವನಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನಾನು 15,20,000 ಮೊದಲನೇ ಪ್ರತಿವಾದಿ ಮೊದಲನೇ ಪ್ರತಿವಾದಿ ನನಗೆ ಆಸ್ತಿಗಳನ್ನು ನಿರಾಕರಿಸಿರ್ತಾರೆ. ನಾನು ಕೊನೆಗೆ 19/10/2007
ಪಂಚಾಯತಿ ಮಾಡಿಸಿ ಫಲಾನು ಕೇಳಿದೆ, ಆ ಫಲಾನು ಕೊಡಲು ನಿರಾಕರಿಸಿರುತ್ತಾರೆ. ಆಗ ಪಂಚಾಯತಿಯವರು ಸಹ ನನ್ನ ಪಾಲನ್ನು ಕೊಡಬೇಕೆಂದು ಪ್ರತಿವಾದಿಗೆ ಸಲಹೆ ನೀಡಿದರು. ಸಹ ಒಂದನೇ ಪ್ರತಿವಾದಿ ತನ್ನ ಪಾಲನ್ನು ಕೇಳದೆ ನಿರಾಕರಿಸುತ್ತಾರೆ. ಆದ ಕಾರಣ ನಾನು ಪ್ರಸ್ತುತ ದಾವೆಯನ್ನು ಮುಂದುವರಿಸಿದೆ. Nowhere she is in the claim or in the evidence says that out of the family joint income, the two properties are purchased. That is item number 11 and item number 4. And the grant was also made in the name of family. So she was said, no evidence, no the Supreme Court judgment by not so cannot be decreed in respect of this property. So these two aspects, my lord, both the courts, my lord, the first appellate court said that plaintiff has not laid on the foundation. So with regard to these two properties, both the courts have concurrently held that they have not laid on the foundation. Because there is no initial burden has not been established, and there is no person not shifting the burden to the defendant to show that this property is self-performed.
In a joint family, we will not give a strict evidence. Only evidence is not acceptable. Next. You are coming to this court in light of the decretal of the suit. Decretal of the suit in respect of the other items, not in respect of the items which has been granted. That is admittedly a joint family property. So this appeal of yours has to be dismissed because they are entitled for share in light of this being the ancestral joint family property. No, not all that. We need not reappreciate all that now.
Because she's a class 1 here, my lord, these are all things, my lord.
Class 1 here? Who is not a class 1 here? In light of Revana Siddhapa's case, they have been treated as equal.
It's wife, daughter, my lord, she's taken. Yes.
Correct. You are the plaintiff. They are the plaintiff.
But in that case, my lord, question of law is my lord. So I will argue on that point.
Now this appeal of yours.
Appeal by the plaintiff.
Your appeal, that is RSA 292.
290 is mine.
Correct. Against the granting of share in favor of the plaintiffs in respect of item number 1, 3, 5.
1 to 3, 5 to 9, and
there cannot be any interference by this court. No interference.
That I argue on that.
There is no interference. Now we are only concerned about this item number 4 to
11.
4, 10 and 12. Where according to you, you say it is your self-acquisition. You have to establish as to what are the materials produced by you to show that you had sufficient income, individual income to purchase the property.
There is no burden on me now.
We will answer that. We will answer that. The plaintiff is the daughter of the first wife. And you are the children from the second wife. Yes.
So this is the evidence. I have read the evidence and the cross-examination also.
We'll take it up in the afternoon. Yes, what is that? Yes, which matter you are mentioning? Huh? $54.
Then finding, the point is that let put relies upon the agriculture.
Notional partition has been granted. Huh?
Not even notional. Only that the father was dead as on the date of marriage. Therefore,
Dismisses your suit.
suit was decreed.
And
Appellate court only relies upon Prakash was
and dismisses your suit, right? By the first appellate court. Material instructions he has not got. 26th. 26th. 26th night at request of the respondent counsel. Yes. ಏನಿದೆ ಅಲ್ವಾ ಅವ್ರೆ ಮತ್ತೇನಿದೆ ಅದರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್? What is that? They have made the submission on additional documents also. We will see. You may come in the afternoon. You come in the afternoon. Madhyana. ಅಲ್ಲ next week ಅಂದ್ರೆ ಒಂದೇ ವಾರ ಉಳಿಯುತ್ತೆ. It's difficult for this court to. ಅದು Monday ಎಷ್ಟು further hearing ಇದೆ? Monday or Tuesday at 2:30. Monday at 2:30 ಅಂತ.
CM number 40.
Yes, you did not inform the other side. Mr. Counsel, ನೀವು
ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೇನೆ.
Before making a mention to the court at 10:30, are you not duty bound to make a ಅವ್ರಿಗೆ ಹೇಳಿ submission?
ಬಂದಿರ್ಲಿಲ್ಲ ಅಲ್ಲ ಕೇಳಿದೆ ಇನ್ನು ಬಂದಿಲ್ಲ ಅಂತ.
Afterwards, the counsel comes and makes a submission that they are not informed.
Monday ಹಾಕಿ no problem. Monday.
ಯಾವ್ದದು? Serial number?
Serial number 40 ಅವ್ರು ಹೇಳಿ.
Serial number 40.
ಹೌದು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀವಿ.
26th.
26 ಬೇರೆದು ಹಾಕಿ 23ನೇ ತಾರೀಕು 24 ಹಾಕಿ ಮಂಗಳವಾರ ಬೇಕಾದ್ರೂ ಹಾಕಿ 26 ಬೇರೆದು ಹಾಕಿ.
Mr. Counsel, Monday, Tuesday, now labor matters.
24 ಹಾಕಿದ್ರು ಪರವಾಗಿಲ್ಲ, 23 ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ.
27.
ಅಲ್ಲ ಎಲ್ಲ
ಆಯ್ತು 27.
26, 27 ಎಲ್ಲ ಆಗೋಗುದಲ್ಲ. ಅದರ್ವೈಸ್ ನಾನು ಕೇಳ್ತಾ ಇರ್ಲಿಲ್ಲ. 25 ಬೇಕಾದ್ರೆ ಹಾಕಿ.
We are not hearing second appeal. ಅಲ್ಲ ನೀವು second appeals ಎಲ್ಲ ನಾವು 24th, 23rd, 24th year ಮಾಡಿದ್ರೆ ಬೇರೆ ಎಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು ಅವಾಗ?
ಯಾಕಂದ್ರೆ
27
ಆಗೋಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
We have fixed a roster for certain.
ನಂದೇನಿಲ್ಲ ಅಭ್ಯಂತರ ಇಲ್ಲ. ಯಾಕೆಂತಂದ್ರೆ
27.
ಅಲ್ಲಿ 30ನೇ ತಾರೀಕು ಹಾಕಲಿಕ್ಕೆ
27. Yes. Next is. Have you informed the appellant counsel? Have you informed? You must have called. Have you informed? ಮತ್ತು ಮಧ್ಯಾಹ್ನ ಇತ್ತು
Court officer. Court officer. Madam. Court officer, excuse me, madam. Sir. Court officer. Court officer.
or the family members who did not choose to contest in this.
In so far as this aspect of the sale in respect of one property, item number 1. He contended that it is the self-acquired property of dependent number 1.
He says that it is a self-acquired property. However, other family members have joined in execution of the sale.
Other than the daughter.
One of the daughter is joined.
One daughter has not joined.
The family that was made available to you did not disclose the names of these three daughters.
Correct. On 9/11/2012, within a span of 20 days, you file a suit. This is assumes, as this court indicated yesterday. Please talk, ask them to talk and resolve, come back to this court.
He had offered around 27 lakhs for all the legal expenses. In order to see that this particular property is brought on the assault proceedings. The counter offer according to me what was given is, is problem that these people do not have even an house to give me a site in that particular level. You will see that it is that was the counter offer that was made. They are prepared to talk on a directly. I can allow the parties to talk.
Let them talk. Let them talk. No. See, we don't know. Let them talk. Let them. See, he has to save his property now. That is on merits. Whose signature?
Village account signature is on.
Village.
Which they are permission at the time of the sale.
And why did you not produce this before the?
In fact, they have shown only 4 members. Only 3 are there.
3 members. When this is taken into consideration, he is a bona fide purchaser.
It so happens. If that particular document going to be made subject matter of the original suit, there have been certain cross-examination whether this particular document has been created subsequently or because this was the document that was made available at the time of sale.
He is defendant number
6.
6. What about the other defendants? Defendant number 1 is no more. So defendant number 2 to 5. They are represented by counsel here.
They are not represented. They did not choose to contest the proceedings.
They are your brothers. Your brothers and sister.
His brother,
Mother.
brothers,
Oh. That is separately. That is a different.
One has brother, as they say. Our children have entered into engineering. He has also taken. During all these proceedings, they have kept on taking money from. That's something they do. The website, whatever they say. So father and brothers have taken.
She has not been given anything. She is the plaintiff now before the court. One daughter. Whatever it is now, when it comes to settlement, you have given to other brothers and other sisters. Now she is there before the court, but as the plaintiff want to pay, who is the daughter of Sanjeev Bappa. So defendant number 1. And without their making her as a party to that sale deed, the sale deed has been executed. Though you may say that you are a bona fide purchaser, not aware about the other legal heirs. Is it not?
Because some of them have.
Submissions are made in litigation.
This court has not yet framed an opinion. Now in the event this court holds that defendant number 1 along with other children had no independent right to sell the property in favor of defendant number 6 in light of another daughter being there. Then what happens to the sale? To the extent of her share, it can be protected. She will get whatever share she is entitled for. And the sale deed would be valid only to the extent of the share of the other dependents. Is it not? No, you have produced, that is one thing. This You to show that you are the bona fide purchaser, having inquired about all the legal heads. There is no materials forthcoming before the trial court or before the first appellate. So this is for the first time you are producing, though they have raised a condition, though they have raised a contention before the trial court that there are other legal heads, and willfully or unwillfully they have not taken the signatures of other legal heads of or other joint family members. So now, when dependent number one sells the property along with other children, not including the plaintiffs, then to that extent of their share, it would be always protected, right? Is it not? That is the proposition of law. If at all you, how did you pay that amount? You were working.
You need the details.
How did you pay that auction amount? What was your avocation? What was your self-acquisition? What was your self-employment? What is that evidence to show? That all comes. See, if we can say something to the appellant, we can definitely ask the dependent. Right? See, if the auction amount is paid from the joint family funds, then it becomes the joint family property, even if it is purchased by dependent number one in his individual capacity. And this is purchased when auction.
We did not go for auction. For non-payment of taxes, name of the government was introduced. Subsequently, they paid the tax and got the name back restored in the name of the person.
So tax was paid.
So, that's all.
Then,
Because they say it was back.
then it will not doesn't partake the character of self-acquisition of dependent number one. Because let me tell you, dependent number one, when he purchased the property, he was not married. He was married then.
When the back was taken as Padala, it was standing in the name of the father. Subsequent to payment of taxes, it came to be re-entered in the name of the son.
So there were other children for this Gopalappa.
Not is the father.
Gopalappa. He had other children.
And he had one more son.
Now the other son and daughters are not claiming. So only the Sanjeevappa's children are before it. So Sanjeevappa has sold the property. One more thing. If Sanjeevappa was the absolute owner of the property, why did he take the other legal heirs consent to? The sale deed is executed by other children also, right? Witness. They are executed. Then why did you take them? If at all, this dependent number one was the extra protection takes the lead.
The minors also to be partition that second.
Yes. What you propose to do? We'll refer to the mediation. For now, come back tomorrow.
Any person available if they like.
Yes, who is available now today?
Senior member of the bar not there.
Any name you can suggest? Who is the senior counsel? Senior advocate. Yes, he is. He's a mediator. You'll mediate. Yes. As per the direction. No, your counsel is already here. Mediation. In light of the direction in light of the direction of this court on 19/9/2024, the parties are present before the court. This court notices that there is a possibility of settlement. And in light of the same, the parties are referred to the mediation center. Mediation. You appear, Akira? So what is your name? R. Chandrana, to be a mediator for the parties. Correct. And the mediator to be facilitated before in the mediation, High Court Mediation Center. Yes. Today at around 3:30. 3:30. The next matter. So 3:30. So 3:30. At 3:30. The list this matter on 23rd after securing the report from the mediator. Only ಕಳಿಸ್ಬಿಡಿ ಈಗ ಸದ್ಯ ಆಮೇಲೆ yes our matter ಕರೀರಿ ಚಂದ್ರಣ್ಣ yes you come okay our matter ಕರೀರಿ 21 yes yes madam. Now the other counsel is not appearing, so you have your turn. Have you looked into the papers? How is the imposition of cost of 1 lakh justifiable? That's all here. This has to be answered in his favor. Non-paying of court fee, how can they impose the cost of rupees 1 lakh? Is it not? We thought of settlement, but they are not agreeable. Neither your party was agreeable.
But the payable is only 100 rupees. Even memo was prepared. Can you
Looking
wait?
into the facts, the court, the first appellate court felt that some amount should be paid to her. That was only out of extra. Her possession itself was for so many years without any rents or anything. She was in possession of the property. That was a benefit to her. That's all. Interest. As approached. Spot. Assailing the judgment and decree dated 27/6/2017 in RA 15040 of 2016 on the file of the 5th additional district and session judge at Devanagari, first appellate court, confirming the judgment and decree dated 4/3/2016 invoice number 2297 of 2006 on the file of the senior civil judge and German civil Devanagari, subject to the payment of cost of rupees 1 lakh payable to the defendant. Payable to the parties herein are referred to as per the rank before the trial court for the sake of convenience. For declaration and for permanent injunction. Subsequently, by way of amendment, plaintiff deleted the relief of permanent injunction and sought relief of mandatory injunction and proposition. The father of the plaintiff purchased the vacant site bearing old BP number 43, measuring east-west towards north 61 feet and towards south 39 feet. And the registered sale deed dated 29/1/1950. The scheduled property was a vacant land site bearing old BP number 43. East-west 39 feet and north-south 45 feet is the portion of the property purchased by the plaintiff's father and the registered sale deed dated 29/1/1950. In a family partition, the suit scheduled property was allotted to the plaintiff. And the plaintiff is the owner in possession of the suit scheduled property. The plaintiff averred that the defendant without any right, title, or possession over the suit property obtained panchayat khata in her name and building license to put up construction. And she has put up a constructed shed in suit schedule site measuring 30 feet into 26 feet. And hence the suit might be filed. On notice, the defendant appeared and filed written statement. Inter alia contending that from 1990, the defendant and her family members are in possession and enjoyment of the suit property and perfected the title by way of first possession. The trial court on basis of the pleadings framed the following issues which follows. In order to substantiate their claim, the plaintiff examined himself as PW1, one witness as PW2, and marked documents as Exhibit P1. On the other hand, defendant examined herself as PW1, two witnesses as PW2 and 3, marked documents as Exhibit B1 to D. The trial court, on the basis of the pleadings, oral and documentary evidence, declared the suit of the plaintiff, declaring the plaintiff as the absolute owner of the suit vacant site, and by way of mandatory injunction, directed the defendant to demolish the existing illegal construction of the shed put up by her in the portion of the scheduled property. And the defendant was directed to hand over the vacant possession of the portion of the scheduled site in favor of the plaintiff. The plaintiff was directed to pay a court fee on the relief of mandatory injunction and for possession in the office. Agreed by the decretal of the suit, the defendant preferred appeal before the first appellate. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, held that it does not find any reason for interfering with the judgment and decree of the trial court. However, since the plaintiff has not complied with the mandatory requirements, the court interfered on technical grounds and held that and passed an order allowing I number 2 filed by the plaintiff to pay the plaintiff under section 151 CPC for payment of requisite court fee, subject to the payment of cost of rupees 1 lakh payable to the defendant within 1 month. And further holding that failing to comply with the order of paying 1 lakh, the order automatically stands vacated and the appeal stands allowed, setting aside the interim judgment. This court, while admitting the appeal on 28/7/2017, framed the following substantial question of law. No, judgment. Where is that judgment 1988? CPC. Very last. Order 20, Rule 6A envisages regarding the preparation of a decree. Every endeavor shall be made to ensure that the decree is drawn up as expeditiously as possible, comma, and, comma, in any case, comma, 15 days, within 15 days from the date on which the judgment is pronounced. Further, an appeal may be preferred against the decree without filing the copy of the decree. And in such a case, the copy made available to the party by the court shall be for the purposes of Rule 1 of Order 41 to be treated as a decree. Second portion, Madam, from the date on which the judgment is pronounced, 15 days from the date on which the judgment is pronounced. The first appellate court, though, was right in invoking the provisions of Order 20, Rule 6A, CPC, wherein it contemplates that after passing of a decree, within 15 days from the date on which the judgment is pronounced, the decree has to be drawn expeditiously. While doing so, the first appellate court was not justified in levying an exorbitant cost of rupees 1 lakh and directing the plaintiff appellant to pay the said amount to the defendant. This court in Ireland, this court in the case of Devaka versus Veerabasappa Paled, reported in Ireland, 1986, Karnataka, 1701, has observed that the Court Fees Act does not prohibit the court from collecting court fee even after the decree. The said decision placed reliance by the first appellate court has been misinterpreted by the first appellate court and has erred in levying cost of a sum of rupees 1 lakh while allowing I number 2 filed by the appellant. the First Appellate Court failed to consider that non-drawing of decree by the trial court does not by itself cause any inconvenience, injury, or hardship to the respondent in prosecuting her appeal before the First Appellate Court, even in the absence of a decree drawn up by the trial court. And thus, the levying of cost of rupees 1 lakh by the Appellate Court is wholly unjustified and illegal. The decree is for declaration and for possession. The defendant is all the way in possession of the suit property. And levying cost of rupees 1 lakh by the First Appellate Court when Order 20 Rule 6A of CPC either contemplates of imposing of such cost. The First Appellate Court was not justified in passing it and imposing the cost of rupees 1 lakh on the appellate. The substantial questions of law framed by this court is answered accordingly, and this court passed the following order. The regular second appeal is allowed. The impugned judgment and judgment of the First Appellate Court insofar as imposing of 1 lakh cost payable to the appellant defendant is set aside. The rest of the portion of the First Appellate Trial Court and the First Appellate Court starts the
I will pay the court fee.
when you have paid it, right? I number 1 under I number 2, have you paid the court fee?
I number 3 for sending back the records to the trial court for payment of court.
The trial court to draw the decree accordingly on payment of court fee by the plaintiff.
Please, I'm sorry, I'm not in a position to appear physically today for certain reasons. I'm appearing through VC. I hope I'm audible to the court as well as to my learned friend for the respondent.
Yes.
Yesterday, I was arguing on this IA 1 of 23 filed by the appellant. So far as the first question is concerned, your lordship expressed that the first question can be framed. At the time of considering this second substantial question of law to be framed, additional question, my learned friend for respondent number 2 pointed out page number 211 of paper book. Kindly turn to page 211. Hello, status quo order. ಸರ್ವ್ ಆಗಿದ್ದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇದು. If I'm right, that is the portion pointed out by my learned friend.
Yes.
As against that, there is admission by DW1, Deepak, son of Krishnadas, who was the person who had agreed to sell the property in my favor, saying that kindly turn to page 79 of the paper book, specific admission. His father was aware, there was an interim order And 11 months after that, his father disposed of the property in favor of Sarojamma. There are judgments of the Supreme Court and this Honorable Court saying, I have produced all of them, saying that any disposition made after the order passed by the court during the pendency of the suit is invalid and the same cannot be upheld or approved, countenanced by the court. It is an invalid document until judgment civil. That's why I say that second question of law, page 79, Lord, your lordship got it, Lord?
Yes.
79 ಅದರಲ್ಲಿ 1, 2, 3ನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ, ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Yes.
May I read that? ನನ್ನ ತಂದೆಯ ಮೇಲೆ ಈ ದಾವೆಯ ಪ್ರತಿವಾದಿ ದಾವೆ ದಾಖಲಿಸಿದಾಗ, that is OS 509(7) of 1997, ಅದರ ಸಂಗತಿ ನನ್ನ ತಂದೆಯ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ ಎಂದಲ್ಲಿ ಹೌದು. ಈ ದಾವೆಯ 1ನೇ ಪ್ರತಿವಾದಿ ನನ್ನ ತಂದೆಯ ಮೇಲೆ ದಾವಾ ದಾಖಲಿಸಿದ 11 ತಿಂಗಳ ತರುವಾಯ ಎಕ್ಸಿಬಿಟ್ ನೀಪಿ 1 ಜಾರಿ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಹೌದು. 1ನೇ ಪ್ರತಿವಾದಿ ನನ್ನ ತಂದೆಯ ಮೇಲೆ ದಾವೆಯನ್ನು ದಾಖಲಿಸಿ ಘನ ನ್ಯಾಯಾಲಯದಿಂದ ಮಧ್ಯಂತರ ಆದೇಶವನ್ನು ಸಹ ಪಡೆದಿದ್ದಳು ಎಂದರೆ ಅದು ಸರಿ. ನನ್ನ ತಂದೆಯ ಕಡೆಯಿಂದ 1ನೇ ಪ್ರತಿ ಪುಟ್ಟಸ್ವಾಮಿ ಸೊಸೆ ಎಂದು ಗೊತ್ತಾಗಿರುತ್ತೆ. Krishnadas was well aware of the order passed by the Honorable Court. Despite that, of course, there is apparent collusion between them to defeat my right. Hence, second question of law, according to my humble submission, also is required to be framed as an additional substantial question of law apart from the question number 1.
Yes.
And third question, of course, I say that so far as in the absence of any evidence on record, whether trial court is justified in law in ordering that the plaintiff in OS so is entitled for mean profits. Absolutely no evidence, except the statement made by the plaintiff in OS 318. Absolutely, there is no evidence on record.
Yes.
Mean profits.
Yes.
Yes. This is so far as IA 1 of 23 is concerned.
Yes, Mr.
Please, before taking this honorable court through the substantial questions of law, item wise or number wise, with reference to the pleadings and the evidence on record, I would only submit that so far as this exhibit D8 is concerned, your lordship wanted to know what are the steps taken by the plaintiff is in OS 507 to prove execution of exhibit D8. Since admittedly Krishnadas was not available on the date of evidence and he could not deny his signature on exhibit D8, the same has been marked. I do not say that merely because it is marked, I need not prove the document. But whatever steps I could take in the matter, I have taken. I have examined exhibit, witness DW3, Makaya, who was a witness to the document. He was the only person available as on the date of evidence. I have examined him. And the one more thing is, for the reason that that's why I wanted this honorable court to see exhibit P1, that is an admitted document executed by Krishnadas in favor of Sarojamma. The subsequent sale deed during the pendency of the suit, my suit, and in the presence of the order of
Kindly restrict your argument only to the agreement which has been entered first. Agreement.
Please, ma'am. That is exhibit D8 ಅನ್ನು ಓದ್ತೇನೆ.
And now the consequences what followed after that. You did everything. HRC was there. You were the tenant. HRC went. You lost in the before the HRC, HRRP, HRC, RP, and then what happened? Execution was levied. In the execution, what happened? You said that during that period, there was an agreement. This was not brought to the notice of the executing court either by you or by the Krishnadas.
Krishnadas, ಹೌದು. ಅದು that's a factual aspect which cannot be disputed by me. Because this.
Though you say it is symbolic possession, but there is no material to show that it is only symbolic possession. When an execution petition came to be closed, holding that it has been satisfied,
but
not on the that it has been settled.
But having regard to the fact that the signatures on the admit, because the court can compare the signature on exhibit D8 with reference to some admitted document. Admitted document, one of the admitted documents is exhibit P1, the sale date, that cannot be disputed. Otherly signature, it contains about 5 to 6 pages. One signature tally agodilla. There are other documents.
Why did you not refer the to the fingerprint expert then? Burden was on you to prove that it was his signature on the agreement.
Please, ma'am, one submission.
And if at all, if you would have referred that document to the fingerprint expert, it would have been in limelight that there is variance in his signature in all the documents, and that would have a better chance for you to substantiate. Having not done so, what is your right now?
I can understand that. One submission is that this, while marking this document, it was not objected to on the ground.
Object for they disputed his signature on the agreement in the written statement itself. They denied the document. They denied the document.
Mere denial of the.
They denied the document. The very execution of the document was denied. Where is the question of saying this is not my signature and he denied the document. When the document is sought to be marked, will he say illa nan signature illa, so please don't mark it in evidence? Baralla, there is nothing called like that.
Your lordship is well aware that in all the cases of specific performance, ಈಗ ಸತ್ಯ ಹರಿಶ್ಚಂದ್ರನ ಕಾಲ ಹೋಗಿದೆ. Whenever a suit is filed, in all the cases, 99.9, contention will be taken in the written statement that it is not the signature, the document is not executed. Mere
denial, he cannot say that. He cannot prove negative here. You have to prove that. You have to prove that this is his signature.
ಅದಕ್ಕೆ
what were your efforts done?
No, one submission is mere denial in the written statement is not sufficient, is my humble submission. Second submission is in the while marking the document, had they objected to on the ground, it is not the signature of Krishnadas, that would have given a cause of action for me to file an application. Third aspect is more aspect of signature yavroti tally madodu. In fact, he was advised not to file the application because exhibit P1 agli, exhibit D4, D5 agli.
Would have been so diligent, you would have brought to the notice of the court that this defendant is more inclined to make variance of his signature in all his documents. That definitely is not done by you.
Allah, it was brought to the notice. It has been noted by the court below. The evidence, it will have to be, the court will have to look into the evidence adduced by.
Not that this both the courts have held. What is the nature? What is the
different signature argument ಮಾಡ್ತು ಅದನ್ನು ಬರೆದಿದ್ದಾರೆ. It was definitely pointed out. It was not that
discharge the burden which was casted upon you.
My submission is, of course, that is my submission. For these three reasons, application was no doubt filed. That's a fact which cannot be disputed by me. But the thing is, when son of Krishnadas virtually admits everything, he says
What
that
prevails? What prevails?
the
Evidence.
evidence, the evidence given by his son, DW1, on record, coupled with the fact that the subsequent purchaser in her evidence states that she has no knowledge about the agreement executed by Krishnadas and he never intimated her about the same. All those things I will read. This
No,
one report.
Only relevant ಅಷ್ಟೇ ಓದ್ಬಿಡಿ ಹಾಸ್ಯಗಾರ್ ಅವರೇ. Now we
please.
have your limited scope. You have to say only what is the perversity of the order passed by the trial court and the first appellate court in the absence of you referring this agreement and the admitted signatures to a fingerprint expert.
Please,
You having failed to prove the agreement before both the courts.
And even if for these reasons the application was not filed, whether having regard to the evidence on record, having regard to the admitted documents, signatures of Krishnadas on admitted documents, variance in his signatures, dissimilarities in his signatures,
That is already Mr. Hasigar, we have understood. We have understood that point. According to you, the defendant has not objected at the time of marking the document that this is not his signature, and he has variance in other documents. So this it has to be assumed that he has signed this agreement, according to you.
And I will take your lordship through those things. And to be precise, in fact, I have filed the detailed synopsis virtually.
Yes, we will look into the synopsis then.
And the points for consideration on 16/2/2016. Now with this, I would request this honorable court to take the substantial questions of law framed by this court.
Substantial questions of law are all correlated to each other. This all depends upon the agreement of sale. If you prove agreement of sale, everything comes. Otherwise, nothing comes.
My humble, kindly bear with me. Kindly bear with me.
Mr. Hasegar, we have heard your arguments, not on this occasion, on 3 occasions. We have heard this substantially.
I have one day sufficient. I have in support of the substantial
judgments.
First question of law ತಗೊಳ್ಳಿ ತಾವು.
Judgment ಕೊಡಿ.
First question of law is
first is whether the trial court and the first appellate court have committed any serious legal error in comparing the signatures of the. That is not barred totally.
So far as this aspect is concerned, kindly see.
Your judgment ಅಷ್ಟೇ ಹೇಳಿ paragraph ಹೇಳ್ಬೇಡಿ ಇವರೇ.
Please. The judgment, the lower appellate court judgment and the trial court judgment, if I read the relevant portion, I think that would be helpful.
This judgment, if you are relying on this judgment, in this judgment, this court was the appellant. Was advocate for the appellant there. ILR 2015 Karnataka 520. Which judgment you are referring?
No, I have referred to 3 judgments.
The ILR 2015 Karnataka 520.
One ನಿಮಿಷ. ಅದನ್ನ judgment I thought I can take your lordship through the evidence adduced by DW1.
Evidence ನೀವು ಹೇಳಿ ಇಷ್ಟೆಲ್ಲ.
DW1 evidence ಅನ್ನ I thought I can read it.
ನೀವು synopsis ಹಾಕಿದ್ದೀರಲ್ಲ, we will look into that.
Then kindly ಅಷ್ಟನ್ನು ಮಾಡಿದ್ರೆ ಇದಾಯಿತು, but kindly see the judgments which I want to rely upon.
ಹೇಳಿ.
First judgment is AIR 2008 Supreme Court. ನಾನು ಸ್ವಲ್ಪ ನಿಧಾನ ಮಾಡ್ತೇನೆ ಅಷ್ಟೇ. ಕೈಂಡ್ಲಿ ಪಾರ್ಡನ್ ಮೀ. ಏನೋ ಸ್ವಲ್ಪ ಅಭ್ಯಾಸ ಮಾಡಿದ್ದೇನೆ ಅದನ್ನು ಹೇಳ್ಬಿಡ್ತೇನೆ, ಬಾಕಿ ತಮ್ಮ ಚಿತ್ತ. That is serial number 16 ಫೈಲ್ ಮಾಡಿದ್ದು AIR 2008 Supreme Court 1541.
Is it that, have you produced this, have you placed this on record before this court?
ಹೌದು. That is filed on 16/16.
Much water has flown after that, Mr. 2016.
ಹೌದು, ನಾನು along with ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಮಾಡಿದ್ದು. ಸಿಕ್ತಾ ಜಜ್ಮೆಂಟ್ ಎಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2.
Alcabos.
ಕರೆಕ್ಟ್ Alcabos. ಅದರಲ್ಲಿ now before reading that I thought I can take your lordship through section 45 and 73 of the Evidence Act, which is very relevant. ತಾವು ನೋಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟಾದ್ರೂ ಸಾಕು. ಇದರಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಎಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2, 45 and 73, they are relevant provisions.
Correct. That does not totally bar the court from not looking into the.
I am fully aware of it. ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Having not taken any efforts by you, what is the court supposed to do then?
ಅದನ್ನೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಬರೆದಿದ್ದಾರೆ. ಅದನ್ನು ತೋರಿಸ್ತೇನೆ. Section 45 of the Evidence Act may kindly be seen. I would like to read that. When the court has to form an opinion upon a point of foreign law or of science or art, or as to identity of handwriting or finger impressions, the opinions upon that point of persons specifically skilled in such foreign law, science or art, or in questions as to identifying of handwriting or finger impressions are relevant facts. Such persons are called experts. Now section 73 may be seen. 73.
Yes.
In order to ascertain whether a signature, writing or seal is that of the person by whom it purports to have been written or made, any signature, writing, seal admitted or proved to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing or seal has not been produced or proved for any other purpose. ಮತ್ತೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇರಬೇಕು, ವ್ಯಾರ್ ಸಿಗ್ನೇಚರ್ ಇರುವಂತದ್ದು ಅಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗತ್ತು ಅಂತೇಳಿ ಇದ್ರೆ then it can be referred. The court may direct any person present in court to write any words.
Mr. Hasegar, the court is prevented from looking into that document and verifying, comparing the signature. Is it debarred from doing that?
Under certain
proposition of the law, proposition of law is the court is entitled to make comparison.
Now that I have taken your lordship through these relevant sections, kindly go to the judgment at serial number 2. Relevant portions I will read. Judgment at serial number 2, Alcabos case. ಅದರಲ್ಲಿ paragraphs, ಅದರಲ್ಲೂ comparison was made by the court. Paras 9, 14 to 16. Para 9. Yes, para 9. Kindly turn to.
Kindly go to the reasoning portion.
Yeah, the reason.
Para 15. Para 15.
ಅಲ್ಲ ಈ ಕಂಟೆಂಟ್ ಯಾವ ಪಾಯಿಂಟ್ಸ್ ಅರ್ಜ್ ಮಾಡಿದ್ದು ಅದರ ಸೆಕೆಂಡ್.
Para 15 ಬನ್ನಿ. Para 15.
Please.
While there is no doubt that the court can compare the disputed handwriting bar signature.
ಅದನ್ನೇ ಓದ್ತೇನೆ. ನಾನು ಸ್ವಲ್ಪ ಸ್ಲೋ ಇದ್ದೇನೆ ಅಷ್ಟೇ.
Comparison by the court without the assistance of any expert as always.
Para 14 is also important, madam. Para 14 is also important.
When you have not referred the matter to the fingerprint expert, what is the court supposed to do? What is the court supposed to do?
Even if having regard to the evidence on record, it will have to decide.
No, not
that is the view taken by the Supreme Court. ತೋರಿಸ್ತೇನೆ, ನಾನು ಪ್ರಯತ್ನ ಮಾಡೋದು ಮಾಡ್ತೇನೆ. While there is no doubt that court can compare the disputed handwriting, signature, finger impression with the admitted handwriting, signature, finger impression. Such comparison by court without the assistance of any expert has always been considered to be hazardous and risky. When it is said that there is no bar to a court.
Andre, you mean to say the court should refer it to the fingerprint expert in material whether you file it or not, and it is for the court to take evidence and give case to the plaintiffs.
That is what the Supreme Court. That is what the Supreme. That is what the Supreme Court says. Adana ಆ judgment ಅನ್ನು ತೋರಿಸ್ತೇನೆ.
That contest. Yes.
That is what the Supreme Court says. It goes without saying that it can record an opinion or finding on such comparison only after an analysis of the characteristics of the admitted finger impression and after verifying whether the same characteristics are found in the disputed finger expression. ಇದರಲ್ಲಿ admitted document ತಗೊಂಡ್ರೆ P1 ತಾವೊಂದು ಸ್ವಲ್ಪ ನೋಡಿದ್ರೆ ಅನುಕೂಲ ಆಗ್ತಿತ್ತು. ಒಂದು ಸಿಗ್ನೇಚರ್ ಟ್ಯಾಲಿ ಆಗೋದಿಲ್ಲ, ಅವ್ರ ವಕಾಲತ್ ಸಿಗ್ನೇಚರ್ ಟ್ಯಾಲಿ ಆಗೋದಿಲ್ಲ. D4, D5 admitted document ಅವರದ್ದೇ ವಕಾಲತ್ತು. It does not tally with each other. ಒಂದು ಸಿಗ್ನೇಚರ್ ಟ್ಯಾಲಿ ಆದ್ರೆ I can understand. I fully agree with the honorable court. ಮುಂದೆ the comparison of the two thumb impressions cannot be casual or by a mere glance. Further, a finding in the judgment that there appear to be no marked differences between the admitted thumb impression and disputed thumb impression without anything more cannot be accepted as a valid finding that the disputed signature is of the person who has put the admitted thumb impressions. Where the court finds that the disputed finger impression and admitted thumb impressions are clear and where the court is in a position to identify the characteristics of finger prints, the court may record a finding on comparison even in the absence of an expert's opinion. ಇಲ್ಲಿ ಯಾವ ಡಾಕ್ಯುಮೆಂಟು ಟ್ಯಾಲಿ ಆಗೋದಿಲ್ಲ, ಅವರದ್ದೇ ಡಾಕ್ಯುಮೆಂಟು, ಅವ್ರ ವಕಾಲತ್ತು. But where the disputed thumb impression is smudgy, this is very important, vague or very light, the court should not hazard a guess by a casual perusal. ಅಲ್ಲಿ thumb impression ಬಗ್ಗೆ ಮಾಡ್ತಾ ಇದ್ರು. ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲಿ ಅಡ್ಮಿಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ತಾವು ನೋಡಿದ್ರೆ, ಅವ್ರ ವಕಾಲತ್ ನೋಡಿದ್ರೆ, ಒಂದು ಯಾವ ಸಿಗ್ನೇಚರ್ ಈ P1 ಅಲ್ಲೇನೆ his own document, his own sale deed in favor of ಸರೋಜಮ್ಮ, ಒಂದು ಸಿಗ್ನೇಚರು ಟೆಲಿ ಆಗೋದಿಲ್ಲ. And then the decision in Murli Lal Supra and Lalit Popli should not be construed as laying down a proposition that the court is bound to compare the disputed and admitted finger impressions and record a finding thereon, irrespective of the condition of the disputed finger impression. When there is a positive denial by the person who is said to have affixed this finger impression, and where the finger impression in the disputed document is vague or smudgy or not clear, making it difficult for comparison, the court should hesitate to venture a decision.
This is available to the person who denies his signature. It is for the benefit of the person who denies his signature, not for the plaintiff who says this is his signature. It is for you to prove it.
Absolutely, that is what I say. ನನಗೆ ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ ಏನಿದೆಯೋ ಮಾಡಿದ್ದೇನೆ. I have examined DW3, ಆ ಎವಿಡೆನ್ಸ್ ತಾವು ನೋಡಿ. ಅದರಲ್ಲಿ ಎಲ್ಲೂ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ. ಮಾಕಯ್ಯ, when the document was marked, it is not suggested to him. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಲ್ಲಿ ಇದು ಈ ಕೃಷ್ಣದಾಸ್ ಅವರ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. Nowhere it is suggested to the witness who has produced the document, through whom the document is marked. One sentence iddre I can understand.
Hasegar avre ಎಷ್ಟೊತ್ತು ಮಾಡ್ತೀರಾ ಹೇಳ್ಬಿಡಿ. How much time you require to argue this matter?
I am sorry, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳನ್ನು ಹಾಜರು ಮಾಡಿದ್ದೇನೆ.
Just read the paragraph.
I will point out. ತಾವು ಕೇಳಿದ್ರಿ
ಎಷ್ಟೊತ್ತು ಮಾಡ್ತೀರಾ ಹೇಳ್ಬಿಡಿ. You can tell the others who are waiting before this court.
ನನಗೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು 10-15 ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ. ಅದನ್ನ
ಎಲ್ಲ ಓದ್ಬೇಕಂತಿಲ್ಲ. ಜಸ್ಟ್ ಒನ್ ಪ್ರಪೋಸಿಷನ್ ಗೆ ಒನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಷ್ಟೇ ಕೊಡ್ಬೇಕು. ಯು ಕ್ಯಾನ್ ಗಿವ್ ಪ್ರಪೋಸಿಷನ್ 10 ಜಡ್ಜ್ಮೆಂಟ್, ಒನ್ ಪ್ರಪೋಸಿಷನ್ ಆಫ್ ಲಾ ಗೆ. ದಿಸ್ ಆಲ್ ಸೆಟಲ್ಡ್ ಅಲ್ವಾ? We have the act which says what it is very clear. With so much of experience, I don't think you should hold this court for a long time.
I am
Is it
sorry,
not?
I am sorry, very sorry. ತಾವು ಕೇಳಿದ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರೇ ಹೇಳಿದ್ದಾರೆ. Merely because it is.
We know this is the proposition, you have said so. One proposition, you have 10 judgments. Is it fair on your part?
No,
Give
there is
one
a
judgment.
There is
for
a
one
judgment of the Supreme Court which says merely because it is not referred to handwriting expert, the court cannot simply say, I will peruse and say whether it is a signature.
Correct,
Court,
correct.
even this honorable court can now, if this honorable court feels that this can be sorted out through the opinion of the expert, this honorable court can definitely refer the matter to the
Why
handwriting
should we
expert.
refer the matter and give a benefit to the plaintiff or any of the parties to say that there is a, this is the signature of so and so? It is for you to do your job.
That is what the Supreme Court says, madam.
I mean,
Adana judgment.
But for reading that, we know what has been said by the apex court.
No, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ ಮತ್ತೊಂದು ಜಡ್ಜ್ಮೆಂಟ್
ಹೇಳಿ, you have read this para 15. Next judgment ಯಾವ್ದಿದೆ ಹೇಳಿ?
ಅಲ್ಲ, para 16 ದಲ್ಲಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪೋರ್ಷನ್ಸ್ ಇವೆ.
You have argued this matter for admission for 3 days. So you want this matter for final hearing to be argued for 1 month? Is it your contention? Hangidra, let it be, make this clear to you that we will not hear this matter for more than 10 minutes now. ನೀವು ಯಾವ್ದ್ಯಾವ್ದಿದೆ ಅಂತ ಹೇಳ್ಬಿಡಿ ಮಿಸ್ಟರ್ ಹಾಸ್ಯಗಾರ್ ಅವರ.
ಪ್ಯಾರಾ 16 ದಲ್ಲಿ ಒಂದು 4 ಸೆಂಟೆನ್ಸಸ್ ಓದ್ತೇನೆ, ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋಗ್ತೇನೆ. ಅದರ್ವೈಸ್ ನನ್ನ ಡ್ಯೂಟಿ ನಾನು ಸರಿಯಾಗಿ ಮಾಡ್ದಂಗ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ, ಮತ್ತೆ ಏನಿಲ್ಲ.
In certain matters you have to always be an officer of the court, Mr. Hasegar.
Definitely.
You reserve your argument for a better case, not in this case.
And I think this is the best case in which I can submit my arguments with reference to the questions of law framed by this honorable court.
1975, you are in possession of this property from 1975, 72. You should not forget that. Yes.
I have been in possession. I was in possession as a tenant. Correct. Since he was in financial difficulty.
In what circumstances and in what circumstances the landlord is forced by a tenant? That is also you are aware. What happened in the execution proceedings? Let us not say anything about it.
His son has admitted
and
that
protect the person, his possession for an indefinite time. Yes, there has to be a cutoff for to certain extent.
No, since he was in financial difficulties, problems, he thought of selling. It
Tenant
is not
uncommon. A tenant is never in financial difficulties. It's always the landlord, because landlord gives this property to the tenant and he misuses all this. This is the perfect example of abuse. That's why the abuse, perfect example of abuse.
Yeah, evidence is other way. Evidence is other way. Evidence is other way.
We consider all that evidence.
Para 16, dalli about 15th line from the top. The scribe's evidence was unsatisfactory. It was also difficult to believe that the first defendant, an illiterate old woman from a village, would enter into an agreement of sale on 5180 with the plaintiff, and even when he is ready to complete the sale, sell the property to someone else hardly a month thereafter on 11/2/1980. In this background, the finding of the first appellate court, recorded without the benefit of an expert opinion, merely on a casual perusal, that there appear to be no marked differences between the thumb impressions.
Because the circumstances, even if you look at the facts of this case also, that was a lady who was an illiterate old woman and her signature was not referred. That was the context of passing of this order. Yes.
Please, ma'am. Kindly, next judgment is ILR 2015 Karnataka 520.
Yes.
ಅದರಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 2.
ಎಲ್ಲ ಒಂದೇ ಜಜ್ಮೆಂಟ್, 3 ಸಲ ನೀವು ಬೇರೆ ಬೇರೆ ಜಜ್ಮೆಂಟ್ಸ್ ಹಾಕೊಟ್ಟಿದ್ದೀರಾ. ವಿಚ್ ಇಸ್ ದ ಜಜ್ಮೆಂಟ್ ನಾವು ಯು ಆರ್ ರೆಫರಿಂಗ್ ಟು?
ದಿಸ್ ಇಸ್ ಅದೇ 16 to 16 ಫೈಲ್ ಮಾಡಿದ್ದು. ನಾನು 3 ಸಲ ಜಜ್ಮೆಂಟ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ.
3 ಸಲ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಹೌದು ಹೌದು.
Yes.
Judgment at serial number 3. Paras 13 to 16. Judgment of this honorable court.
ಯಾವುದು?
the ILR 2015 Karnataka 520. Judgment at serial 3. Your Lordship got it, Lord.
Responding. ILR?
ILR 2015 Karnataka.
ಇದು R ಅಂತ ಮಾರ್ಕ್ P ಅಂತ ಮಾಡ್ಕೊಂಡು A ಅಂತ ಮಾಡ್ಕೊಂಡು yes.
ಅದರಲ್ಲಿ
In that judgment,
para.
I was the counsel appearing for the appellant in that matter.
Please. The second, fourth question of law framed by the court, whether the defendant proves that late so and so has bequeathed all mud and mud properties to him during his lifetime through a will dated 5/3/1992. ಅದಕ್ಕೆ ಉತ್ತರ para 13 to 16 may kindly be seen. Para 13. Whether the court framed 3 questions. Second question is relating to this. Whether the trial court is justified in comparing the admitted signatures of deceased so and so with the admitted signatures by invoking section 73 of the Act without getting a report from the expert. Paras 13 to 16.
Yes, yes.
The entire case, the para 13 I am reading now. Entire case of defendant is dependent upon exhibit D1. Yes.
This was arising out of non-referring the matter to the fingerprint expert. There was an application filed by the appellant, and in that circumstances, the court passed this order. So, when an application is filed, asking the matter to be referred to a scientific expert, then in that circumstances, the court could not have compared the signature. Was the opinion of this court. That cannot be equated to the present facts.
13 to 16 are, according to me, relevant paragraphs.
Yes.
Adರಲ್ಲಿ para 16 ದಲ್ಲಿ ಒಂದು sentence ಓದ್ಬಿಡ್ತೇನೆ. In this way of the matter, the trial court is not justified in comparing the disputed signatures of late with the admitted signatures by invoking section 73, more particularly without calling for a report from the expert.
Because there was an application filed by the appellant. That was in that context. Here, there is no application filed by you.
In this case, no application could be filed for obvious reasons which I have already explained.
Because there was variance in the signature of all the admitted signature of the defendant as well.
And it was not objected to on the ground that the signature is not that of Krishnadas. And
yes.
No, not even a sentence in the cross-examination of DW3 saying that this is not the signature of Krishnadas.
Yes.
And now next judgment is AIR 1996 Supreme Court 1140 on 14/7. There are 2 judgments filed on 14/7. Kindly see those judgments. 14/7.
I request Mr. Hasyagar, please give the memo by way of citing all the judgments. You have given memos on 3 occasions. This court has to look into all those memos. So kindly make a memo of citation and give all the citation in a memo, in one memo.
ಇದು ಎಲ್ಲದರೊಟ್ಟಿಗೂ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು.
ಒಂದೇ ಕೊಡಿ, ಒಂದು ಮೆಮೊ ಕೊಡಿ. Don't give so many citations and different memos. You are reading one citation ಇಲ್ಲಿ, one citation ಇನ್ನೊಂದು ಮೆಮೊದಲ್ಲಿ. How is this court going to look into all that?
I am sorry for the inconvenience caused to the honorable court.
Yes.
On 14/7, I have filed.
We want the way the citation has to be filed in a particular manner. One memo you file on one day, it has been filed again on 2-3 occasions. You are not aware as to which memo you have filed and which judgment you are reading. Is it not, Mr. Hasyagar ಅವರೇ?
ಹೌದು, 14/7 ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ನಾನು ಹೇಳಿದ್ದು.
2009 which you have filed, there is no memo. This is just a judgment.
ಯಾವುದು?
Which is the memo? Which is the date you are saying? 2000?
14/7/23.
ಅದು ನೋಡಿ ಅವ್ರು ಯಾವ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಅಂತ.
14/7/23. ಎಲ್ಲದಕ್ಕೂ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು.
ಇಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಈ 16/2/16 ಫೈಲ್ ಮಾಡಿದಕ್ಕೆ ಮಾತ್ರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತದೆ ಹೆಚ್ಚಾಗಿ. ಬಿಕಾಸ್ ಇಟ್ ವಾಸ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟದ್ದಾಗಿತ್ತು. 16/2/16 ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೆ.
Yes, which is the next judgment you are relying?
14/7/23
Judgment ಹೇಳಿ.
Judgment is AIR 1996 Supreme Court 1140 case of O Bharatan. First judgment 14/7/23. I am sorry for the inconvenience caused to the Honorable Court. 14/7/23. Your Lordship got it, man.
There is no memo of yours here.
ಅಲ್ಲ, ನನ್ನ ಹತ್ರ ಎಕ್ನಾಲಜ್ಮೆಂಟು ಇದೆ. 14/7/23 ಫೈಲ್ ಮಾಡಿದ್ದು. 4/7 ಫೈಲ್ ಮಾಡಿದ್ದೆ, ಆಮೇಲೆ 14/7.
ನೀವು ಯಾವ್ದು ಮೆಮೊ ಇಲ್ಲ. ಇಟ್ಸ್ ಓನ್ಲಿ ದಿ ಸೈಟೇಷನ್ ವಿಚ್ ಇಸ್ ಹಿಯರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಇಲ್ಲ, ಮೆಮೊದೊಟ್ಟಿಗೆ ಫೈಲ್ ಮಾಡಿದ್ದೇನೆ. ಇವ ಎಕ್ಸೆಪ್ಟ್ ದ ಫಸ್ಟ್ ಒನ್ 16 ಫೈಲ್ ಮಾಡೋದು ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿತ್ತು. ಅದನ್ನ ನೋಡಿ ಅಡ್ಮಿಟ್ ಆಗಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಆಗಿತ್ತು. ಉಳಿದದ್ದೆಲ್ಲ ಮೆಮೊದೊಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. 14/7/23. AIR 1996 Supreme Court 1140. Otherly High Court itself compared the signatures. That was a case of election petition. Paras 15 to 23 may kindly be seen. 15 to 23.
Yes.
Para 15. It appears that the learned judge has decided the question of void and invalid votes on insufficient materials and evidence in the case. Majority of the witnesses denied that they have voted for more than once, and they have also denied their signatures in the counterfiles. Under such circumstances, the learned judge could have summoned the documents containing admitted signatures for comparison by an expert and also by comparing them himself. Instead, the learned judge understood the hazardous task of comparing hundreds of disputed signatures which are not having individual characteristics to set aside the election of a candidate, the appellant hearing. And then para 18 ಅದರಲ್ಲಿ ದ ಕೋರ್ಟ್ ಅವರೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. there was no application. That's why I read that para 15. Para 18 on the peculiar facts of this case, the learned judge erred in taking upon himself the task of comparing the disputed signatures on the counterfoils without the aid of an expert or the evidence of persons conversant with the disputed signatures. Therefore, the approach made by the learned judge is not in conformity with the spirit of Section 73 Act. And para 20. Para 20. The learned judge, your Lordship got para 20, madam.
Yes.
The learned judge, in our view, was not right either in brushing aside the principles laid down by this court in AR 79 Supreme Court, page 14, on the ground that it was not a criminal case or taking up upon himself the hazardous task of adjudicating upon the genuineness and the authenticity of the signatures in question, even without the assistance of a skilled and trained person whose services could have been easily availed of, annulling the verdict of popular will, etc., etc. And then and in the next paragraph, to quote, it has been held in AIR 1979, Supreme page 14, as the matter can be viewed from another angle also. Although there is no legal bar to the judge using his own eyes, compare the disputed writing with the admitted writing, even without the aid of the evidence of any handwriting expert, the judge should, as a matter of prudence and caution, hesitate to base his finding with regard to the identity of handwriting which form the sheet anchor of the prosecution case. And para 22. ನಾನು ಅಗತ್ಯ ಇಲ್ಲದದ್ದನ್ನು ಬಿಟ್ಟಿದ್ದೇನೆ. Para 22.
Yes.
The learned counsel appearing for first respondent was not able to convince us that the learned judge was right in comparing the signatures himself. At any rate, in the peculiar facts and circumstance of the case, rendering the findings against the appellant hearing, as we are satisfied on the so and so, was not right in deciding 100 so and so so and so. And then next judgment is ಅದೇ 14/7 in next judgment by our High Court, judgment in RFA 885 of 2006.
Yes.
Paras 22 and 23.
Yes.
22 and 23. Yes, para 22 ಒಂದು ಓದ್ಬಿಡ್ತಾನೆ. para 21 ಒಂದು 5-6 ಸೆಂಟೆನ್ಸ್. para 21 at page 23 ಕೊನೆಯದು ಒಂದು 3-4 sentences. I have carefully and cautiously para 21 gone through the findings recorded by the trial court with regard to issue number 1, wherein the trial court, having discussed the fact, held in favor of the plaintiff that plaintiff PW2, PW1, PW2, PW4 having categorically stated
Opposition of law ಅಷ್ಟೇ ಓದಿ Mr. Hassegar ಅವರೇ. Opposition of law ಏನಿದೆ ಅಷ್ಟೇ ಓದಿ.
Yes, further with regard to interpretation of section 73 para 22. With regard to interpretation of section 73 of the Act, it is pertinent to refer to the judgment of the Honorable Supreme Court in the case of Ajit Sawant Majgavi versus State of Karnataka, reported in AI 1997 Supreme Court 3255. At paragraphs 37 and 38 of the said judgment, the Honorable Supreme Court has observed thus. This section consists of 2 parts.
That is the same proposition of law which says normally it should not compare.
Yes. ಇದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ para 23 ಒಂದು ನೋಡಿ. para 23 ತಾವು ಕೇಳಿದ್ರಿ whether any effort was made etc. Though the plaintiff, para 23, your lordship got it not.
Yes,
So,
yes.
though the plaintiff has not made any efforts to file the necessary application for seeking comparison of signature of defendant 1 on the documents at exhibits P2 and D1 referred to above. However, the trial court on its own considered it necessary to compare the signatures and ultimately came to the conclusion that the signature of defendant 1 on documents at exhibit P2 and exhibit D1 are one and the same, and the said finding of comparison was not warranted in the case. In this regard, it is pertinent to refer to law declared by the Supreme Court in the case of State of Maharashtra through CBI versus Sukhdev Singh etc. Reported in AI 92 Supreme Court 2100, wherein it is held that comparing the disputed material with the specimen or admitted material on record would safely be concluded with the assistance of the expert opinion that the disputed writings are not the handwriting of such person whose signature is required to be tested. In the instant case, neither the plaintiff nor the defendants have resorted to make any application under section 73 of the Act for examination of the signature to be done by an expert. The onus of burden lies on the plaintiff to prove such fact, and he fails to prove the same by
That is exactly against you.
Yes, it is also pertinent to mention that in that view of the conclusion arrived with the trial court, accepting the signature having identical feature, opportunity to the defendant for cross-examination on this fact was curtailed, and thereby the defendant loses an opportunity to defend their case, was denied, and the same was ignored by the trial court. As such, there is violation of principle of natural justice. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, had it been denied by the son of Krishnadas, I would get an occasion to file an application, or had Krishnadas been alive, I would have cross-examined him on this aspect. My submission is, though there was no application filed, that does not mean that when signature is,
how did you discharge your burden? That was the only question which this court is asking you. How did you discharge? Only by leading evidence of an interesting witnesses.
No interesting
not
witness.
By examining the, not examining the by referring the matter to a fingerprint expert.
I have
Yeah.
examined DW3, Makaya, who was a witness. He was the only person available. ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ನಾನು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ. ನಾ ಈಗಾಗಲೇ ಹೇಳಿದ ಕಾರಣಕ್ಕೆ no application for referring the matter to the expert could be filed.
Correct. Because they did not admit they did not say that it was not the signature of Krishnadas.
How?
He wanted
And-
Krishnadas to be alive to cross-examine him.
And the evidence given by his son, DW1, that may kindly be produced by the Supreme Court. Specific admissions are made by him. And next judgment is Madras High Court judgment, which I have given on 3/9/24.
Yes.
3/9/24. ಆ ದಿವಸ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ತಮಗೆ. On 3/9.
No.
First judgment is court ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು ಅದನ್ನು.
ನೀವು judgment ಹೇಳಿ, which is that judgment?
That is judgment of Madras High Court in reported in 2010-3 Madras Law Journal 65. I have given the printout from indiakanun.com. Second judgment given on 3/9/2024.
Yes. ಹೇಳಿ.
ಅದರಲ್ಲಿ according to me, there are 3 or 4 aspects considered in that judgment of Madras High Court. It says whether there is application or not, court will have to exercise power under Order 6 Rule 10A and appoint an expert. That is one aspect. Second aspect is signatures on wakalat and written statement.
After having given Supreme Court judgment, what is the necessary to give a Madras High Court judgment?
No, which says.
Why is it necessary? You have already placed the apex court judgment. You have read the paragraphs. We have also read the paragraphs. So please restrict your argument to the next point, substantial question of law.
ಈ ಕೇಸಲ್ಲಿ ಟ್ರಯಲ್
we don't want to look into Madras High Court because you have already placed the apex court judgment. Yes.
One paragraph.
Let us not involve into other aspects now. Please give another judgment in proposition for the another proposition of law which you want to contend. Is this only your main contention?
No,
is this only your main contention? ಅಲ್ಲ ಇದಷ್ಟೇ ನಿಮ್ದು contention?
ಇನ್ನೊಂದು proposition ಗೆ ನಾನು ಇದನ್ನ
What is that? What is that? Next proposition.
The trial court in this case compare the signature on exhibit DA.
But ಅದೇ ಆಯ್ತಲ್ಲ, that is again the big question, Mr. Rasegar ಅವರೇ.
ಅಲ್ಲ no kindly sorry ಇದರಲ್ಲಿ
you should understand, right? You should understand you are arguing the same point. You are giving 10 judgments by different courts and then also placing apex court judgment. Correct. Apex court judgment we have considered. You have placed reliance. Now, where is the question of considering other high court judgment now? It could be
Madras High Court judgment ಅಲ್ಲಿ ಈ ಕೇಸ್ನಲ್ಲಿ ನಮ್ಮ ಕೇಸ್ನಲ್ಲಿ ವಕಾಲತ್ ಸಿಗ್ನೇಚರು ಮತ್ತೆ ಎಕ್ಸಿಬಿಟ್ ಡಿ
ಆಯ್ತು. That is the same proposition of law which has been done by the apex court. ಮತ್ತೆ ಯಾಕೆ ಮಡ್ರಾಸ್ ಹೈ ಕೋರ್ಟ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Please go to the second substantial question of law, Mr. Hasegar ಅವರೇ. Please,
Madras High Court.
Mr. Hasegar, go to the second substantial question of law after this.
ಇದರಲ್ಲಿ ಒಂದು paragraph 15
ಇಲ್ಲ, not necessary. Next ಹೇಳಿ.
Trial court could not have compared the signature on the wakalat.
You have already argued, Mr. Hasegar. You have already argued that cannot compare the signature ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ, compare the signature with the wakalat ಅಂತ ಹೇಳಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬರೆದಿರೋದು.
ಆಯ್ತು. ವಕಾಲತ್ ಅಂದ್ರೆ admitted signature. That is the admitted signature of the party.
Madras High Court division in judgment says it cannot be done.
Yes, that is why. Yes, next ಯಾವುದು ಹೇಳಿ.
Please. ಈ question ಮೇಲೆ these are the judgments. And the second point is substantial question of law. Whether the court below have committed any legal error that the agreement of sale is not a registered document and not signed by the appellant. Therefore, specific performance cannot be granted on such agreement of sale. So far as that aspect is concerned, I would have taken the honorable court through para 30 of the judgment ಅದನ್ನ ಬರೆದಿದ್ದಾರೆ ಅಂತೇಳಿ ತೋರಿಸ್ತಿದ್ದೆ, ಆದ್ರೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಬಿಟ್ಬಿಡ್ತೇನೆ. ತಾವೇ ದಯವಿಟ್ಟು ನೋಡ್ಬಿಡಿ ಅದನ್ನ.
ಆಯ್ತು, ನೋಡ್ತೀವಿ.
ಹಾ
Already
ಅದ್ರಲ್ಲಿ
given a synopsis.
BIR 2009 Supreme Court 1527
ಯಾವ್ದು? In which memo you have given that judgment now?
16/2/2016 ಅಲ್ಕಾ ಬೋಸ್.
ಆಯ್ತಲ್ಲ, ಅದು ಓದಿದ್ದೀರಲ್ಲ, ಅಲ್ಕಾ ಬೋಸು.
ಅಲ್ಕಾ ಬೋಸ್ ಇದು ಓದಿಲ್ಲ ನಾನು. ಈ ಮಟ್ಟಿಗೆ ಸಿಗ್ನೇಚರು ಮತ್ತೆ ಇದ್ರ ಮಟ್ಟಿಗೆ
Again, you are going to that signature itself, Mr. Hasegar avre. You have already argued, you have given proposition of law in that matter. Again, why are you rotating yourself to that? No,
ಅಲ್ಕಾ
Mr.
ಬೋಸ್
Not
ಅಲ್ಕಾ ಬೋಸ್ದಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಬಗ್ಗಲ್ಲ, ಈ ಅಗ್ರಿಮೆಂಟ್ ಈಸ್ ನಾಟ್ ಸೈನ್ಡ್ ಬೈ.
All this argument for a better case, not in this case, Mr. Hasegar.
No, agreement
Already
is not.
told you that.
Agreement is not signed by the purchaser. That is why no specific performance can be granted until ಬರ್ದಿದ್ದಾರೆ.
The least consequence, the signature of the purchaser, least consequence.
The Supreme Court says it is not necessary.
That is what I am also telling you. That is of least consequence.
Please. And then, so far as unregistered document, whether it can be basis for the suit for agreement of sale, Kalavati's case.
Also, that is also settled.
2010 5 SEC. On those two grounds, the suit is dismissed. Mainly on those two grounds.
Yes.
Mainly on those two
Yes,
grounds.
Mr. You really. Yes, you can.
And then.
No, we are hearing the respondents, Mr. Hasegar. You please will sit. Wait for a while. Let me complete the argument of the respondents. Yes, Phil.
ಉಳಿದ ಪಾಯಿಂಟ್ಸ್ ಎಲ್ಲ ಇತ್ತು, ನಾನು ಅದನ್ನ ಗಮನಕ್ಕೆ ತರಬೇಕು ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದೆ.
Synopsis ಹಾಕಿದ್ದೀರಲ್ಲ, we will look into and pass for this. ಹೇಳಿ. What is that you want to place? ಅದೇನ್ synopsis? No, ನೀವು ಹೇಳಿ, ನಿಮ್ ಕಂಟೆನ್ಷನ್ಸ್ ಏನಂತ ಹೇಳಿ. In execution proceedings, did the Krishnadas or the appellant say about this agreement? Did they say about the agreement? Yes.
My friend may kindly use the mic, madam.
Kindly speak through the mic.
I am sorry. ನಾನು ಇಲ್ಲಿ ಇದ್ದ ತಪ್ಪು ಅಂತ ಹೇಳಿ ಭಾವಿಸುವುದಾದ್ರೆ I would request my friend to use the mic.
No, he is speaking through the mic. We can't deny you that opportunity. Definitely not. Please speak through the mic.
Subsequently, alleged sale agreement. July 1995, second defendant taken possession of the property. Then execution was that execution. Possession of now, though she claims to be in possession of the property, if the manager contacted by Hindu, it is clearly stated that he claims she is residing in their property. And also, from the video cycle, this is the manager contacted by Hindu.
So, as on the date when the Mahazar was conducted, she was not there in the premises. And execution proceedings was concluded. The Mahazar report. Mahazar. Yes.
Nature is clearly stated by the second defendant.
In his written statement. He was not alive. Signature, this Krishnadas was not alive.
The statement to buy matter.
Where is the written statement of defendant number? Who died? Defendant number 1, Krishnadas. Krishnadas was alive when the suit was filed.
He was alive. He died in 2005.
Or written statement person. Defendant number 2 filed written statement. Krishnadas filed. Where is that written statement? Page. Paper book nalli ಇದೆ.
Paper book, I think it is not there. Original records ಅಲ್ಲಿ ಇದೆ.
ಕೊಡಿ records ಕೊಡಿ. No, we'll take our records.
Please.
ಕೊಡಿ. ಇದು ಸೂಟ್ ಕೊಡಿ. ಇನ್ನೊಂದು ಸೂಟ್ ಇದೆ ಅಲ್ಲ. Specific performance ಇದೆ. .6. Yes. Para 7. The first dependent further submits that he has not executed any such agreement of sale, nor has he affixed his signature on the said agreement of sale. ನೀವು ನೋಡ್ಕೋಬೇಕಲ್ವಾ ಅದೆಲ್ಲ. All the work has to be done by the court. Yes, there is denial, Mr. Hasyagar ಅವರೇ.
ಹೌದು, that is what I submitted. Denial ಇದ್ದೇ ಇದೆ. ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ.
ಆಯ್ತು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್.
Subsequent to sale of the property of the notice are served on the thereafter the
When did this Krishnadas die?
Krishnadas died
2005
2005.
Subject to correction by my learned friend.
He has denied the very execution of the agreement. Yes.
after filing letter they declared. And was the party connected. It was not brought to the notice of because there was a wrong address in the place. Subsequently, it got amended. After amendment of that is after 11 months of filing this amendment. Address option. Amended and subsequently.
Correct address was incorporated and then notice was ordered and then you were served with the notice and you came to know about the.
Subsequent to that, first defendant has filed. Second defendant, first defendant, Sarojama has filed.
When possession was already taken, what made the Sarojama to file another suit for possession?
Krishnadas is supported. They are saying together.
Correct. What made her to file a present suit for possession? When was the cause of action according to Sarojama?
The seat of this. Notice from this article. And it was not, though she was illegally in possession of the premises was not. And Krishnadas was assumed in the Sarojama. And property was taken possession to the and there was a misunderstanding between the subsequently, the Rashtra to get out of possession because they had taken into possession of the property.
Yes. Next.
And they were to police refused to take action.
That are all facts. Now, what you say regarding section 73, comparison of signature by the court?
While comparing para 39 of the transport judgment, the page 39 para 39. Page 39 para 39.
Yes.
Shrimati Radha, in order to prove the signature of the Krishnadas in exhibit DA, she herself got marked with Vakalat executed in the of counsel as per exhibit D. This is confronted by the Radha. That is Radha.
Yes.
This is confronted by the by Radha. That is exhibit D. Even the court, in the absence of
You want to say this Radha, that is the plaintiff. Alva, who is Radha? Plaintiff. The signature. So that is an admitted signature. There is no variance according to you.
what has compared the signature of admitted document by defendant. That is Radha. Even if we compare the signature, the court observes, even if we compare the signature of Krishnadas and exhibit D for the DA, it differs which is apparent on data. Under section 73 of the Evidence Act, court can compare the admitted signature in the absence of any efforts made by concerned party. It's very clear case of the court. And now, just because of court appreciated the here on record, the side is putting the name on the court.
Yes.
In support of my case, support of my case.
Yes.
Under section 5. Yes, sir. Court can. Para 50.
Maybe you mark.
539, para 16. When the court finds the disputed and legal impression in admitted cover impression are clear, and when the court is in position to identify the characteristics of the fingerprints, all the set of facts are similar to the present. The court may record finding on comparison, even if the influence of an expert opinion. But when the dispute of infraction is very vague and very light, court should not hazard against by casual use. In this case, there is no such vague like across 20 days another now. Therefore, court has properly appreciated the evidence of data in the absence of the party to the concerned party is failing to be executed.
ಯಾವುದು? Which one? 41 of the
It's more specific ground whether the defendant is rather the defendant as part of the case after the honorable court of commercial and state position. What he has executed an affidavit of saying that which is not a ring of the in a similar case, the unfortunate court deeply regrettable that in our country, often litigates between the landlord and tenants are part of the stage of the tenant witnesses this court. Then he starts the second index of court summer.
that is what this court asked him. When he failed in his attempt to keep his premises intact, he took a plea of this agreement of. That's all. You adapt. Okay, decision.
One sentence by way of reply, Matyanilla.
One sentence ಆಗುದೇ ಇಲ್ಲ. Never it is one sentence.
kindly refer to all the citations referred, furnished by furnished to the honorable court with reference to all the substantial questions of law and the synopsis filed by me along with the points for consideration, and kindly pass appropriate orders. That's all my submission.
The court finds there is an abuse of process of law, we will impose heavy cost on the.
I leave it to the honorable court.
In the event this court finds something.
Please.
ಇವಾಗ ಇದು ಮತ್ತೆ ಇದು petition. 25th 25 for dictation.
Dictation 25th, madam.
Correct. You should be very careful when you are making a submission. You should not be so casual in making submissions, right? And your submission was to the other counsel who has already been heard. Then when you are not present before the court, you should never make a submission on a submission made by your colleague, that too. And when you are not present before the court. This court is first in hearing all the parties, all the advocates, and not to such an extent. 4 days. Yes. Yes, next. From whom have you purchased the property? From all the parties. Which items you have purchased? Item number 9. What is the extent of this item number 9? 1 acre 36 guntas. And you have purchased entire extent from all of them. The appellant has also sold this property. Lakshmamma already. No, I'm talking about appellant here. You purchased this during the pendency of this litigation. List pendants. List pendants. In the event they succeed, you will get. Otherwise, your role is very limited. This item number 9, 1 acre 36 guntas. According to this appellants who are the defendants here, it is their contention that when you have sold the property, in the event if you hold this item number 9 is in their favor, you will not get anything. We are not taking the completing application also. It's just refresh.
87.
Ah.
Number 32/9, 2009. There are 3 appeals. Process referring to the genealogy.
Allah.
Appeal number 77.
Only one suit? Only one suit. 3 appeals.
Well, one is by this defendant, 2 by the plaintiff.
You are the defendant and they are the plaintiff.
But
Why 2 appeals?
the reason is this, first court not declared half share to the plaintiff. Not against which I filed RFA, RA 163 of 2013. And my brother, defendant number 5 also filed another RA, that is 181 of 13. There are 2 Lord appeals by the defendants. It is RA 163, 30 and RA 191 now 30.
Yes.
But now this RSA 970 before the lordship is filed by the defendants on the prior.
Yes.
As against their judgment in RA 163 of 30.
What happened in 163?
163, my lord, what happened when the first appellate court has modified the decree, saying, my lord, she is entitled for 1/4 share. Instead of half a share, half share.
1/4 share.
1/4. And so far as property number 563 to 5 is concerned, court held that those properties are not the properties of the family at all. It is excluded now.
Yes.
As much as 4 acres of land has been excluded out of 8 acres, which is subject property. Well, only getting 4 acres, my lord.
That is item number 1, 2, 6 and 9. 6 to 9, huh? No.
8 to 5.
That is the discussion. That is discussion.
1, 2, 6
to 9. And you are aggrieved only to the extent of 9, item number 9? All.
This is fallen to my share.
Yes.
So now there were 2 appeals approved by the findings before by the first appellate.
By non-granting of share, huh?
Modifying.
Holding 1/4.
Excluding my lord 3 properties.
3 to 5.
That is the appeal. 2 appeals because difference are filed to.
Yes.
Two the facts there is for the lordship is, as I said, Lord, there were 9 items. Genealogy is raised to 77. Lord, the common ancestor is Bajaya. And Mariappa and Chikkanna they had 4 children.
You are in fact aggrieved by granting of share to the plaintiffs to whatever extent. They are not entitled. They are not entitled for.
All parties concerned, whatever had fallen into their share, they have sold it all. That is our defense. Not the Mariappa is father of plaintiff. The plaintiff is not Lakshmama. That is not Pelisi. She is the 2nd generation. Vijaya, Mariappa, Veeramma, Lakshmama. Mariappa had 2 wives. That is her father had 2 wives. Lord Mariappa and Chikkanna, And third one. Chikkaya is written, but here Chikkanna. Chikkanna is the
Father of the defendant.
father of the defendant.
Chikkaya is defendant number 1.
Chikkaya is different number.
One.
Chikkaya is not different number. His father of defendant 1 to 5. Father of defendant number 1 to 5.
So Chikkaya is not a party.
Chikkaya, yes, this is.
So defendant number 1 is who? Chikka Doddamma is she is a party.
Chikkadamma, my lord, is not made a party.
So defendant number 1 and 1 to 6 are the children of Chikkaya. Huh?
Not
Okay.
1 to 6. 1 to 5. 1 to 5.
6 is not there.
6 is the sister of my lord Lakshmana.
Yes, yes. 1 to
6 is
5.
the sister of Lakshmana.
Yes. Now the first generation, nobody is alive. This is the second generation.
And that, my lord, several people have been left out. But kindly note before going to any other aspect. Gangamma is not made a party. Being a daughter of Vijaya, Lord, Chikka Gangamma is not made a party. Then look at the extent that Chikka Gangamma, she is one of the daughters of Lord Vijaya. She is not made a party. And my lord, Mariappa, second wife Muniamma. Second wife Muniamma. Mariappa, second wife Muniamma.
That is not necessary because Mariappa's entire branch is getting one share.
May be necessary because she is entitled 1/4 share. So she is denying one, my lord, that is relevant. That's why.
Second wife is not made a party because
And children also.
that would be internal between Lakshmamma and the second wife, which is the branch entire of Mariappa.
No.
Alla, Mariappage,
Mariappa,
aito,
children are not made a party.
Lakshmamma matte Chikka Amma and Parvatama is there.
Lord, kindly say Veeramma. Veeramma is first wife.
Correct.
Lakshmamma is the plaintiff. Chikkatayamma is not made a party, but she impeded. So she is defendant number 6 now. Lord, another one is Paratama. Paratama is not made a party. She is not made a party at all.
Right. Now what this court is tells you is Mariappa, Chikkatayamma, Chikkaya, Gangamma and Chikka Gangamma are belong to one family. So this Mariappa's branch is represented by Lakshmamma, Chikkatayamma and Parvatama. Though the second wife is not a party, in an inter-se partition between Mariappa and this branch, it may not be necessary.
It cannot be necessary, but if she is specifically allotted with 1/4 share.
Who? The wife.
Think of word plaintiff.
Plaintiff, 1/4 share to that Mariappa's branch. That is for the Mariappa's branch. Inter-se, let them do whatever they want. They will get only notional. The second wife's children, if at all during the subsistence of first wife, if second marriage takes place, then they'll get only notional partition. So we'll leave that portion apart. So we will not look into that. Just tell how did what is the nature of the property and what is your contention?
As for the partition oral period by us, my lord, they said, my lord, the joint family property. But my lord, there is nothing in the plain nor in evidence to be effect that to show that, my lord, either there existed a joint family, nor there is a joint family property. Except a sentence, self-serving sentence in the plain that this belongs to joint family property. Except that, my lord, nothing is on record. As he said, she left this joint family in the year 1969. That is, after the death of her father in the year 1966, every.
When was the partition according to you taken place?
That is taken place, Lord. But my return statement is on 6/10/2005. I stated in my return statement that 5 decades before that. That means must have been marked during 1955 because my return statement is on 6/10/2005.
So 5 decades and the 50 ವರ್ಷ, na?
5 years. So it should have been, my lord, ought to have been, my lord, in and around 1955. No, my lord. What is that allotted to the Mariappa share in the partition? Is 3 items. And what is allotted to the defendant are the items.
Did you mention in your written
Yes,
statement which are the
exactly.
properties which has been allotted?
So what is allotted to Mariappa was 84/2. Measuring 1.36 acres.
Yes.
That is, my lord, item number 9 before your lordship.
Item number 9.
9.
Ah,
98/1 measuring 32 guntas. And my lord, 87.7 measuring 1.1 acre and 2 guntas.
ah.
My lord, around, my lord, 3 acres and 38 guntas. Around 4 acres of land, my lord,
Yes.
was allotted to his share.
Ah.
But out of these 3 items, my lord, he has alienated item number 9. That is 84/2. As per exhibit P6.
He has already allotted.
Yes. But this is important because what was allotted was alienated as per the moral partition. It's not a case, Manoj, straight away I'm saying that it's self-acquired property. I bought it from
It
elsewhere.
was sold by whom?
Sold by Manoj, different number 2.
Dependent
Sold by, sorry. Sold by Mariappa.
Mariappa.
Sold by Mariappa.
In the year?
Exhibit P6.
In the year?
In the year 1961. That is on, my lord. 11/10/1961. 11/10/1961. But this was told to one Chikka Kallaya. In turn, my lord, from whom different father had purchased it. This is where, my lord, it makes a difference. When it comes to Baltico's proof, my lord, this is important because it is not my case that I have purchased property independently.
According to you, there was a partition effected before 1960, 1995, according to you. 55. After the partition, the property which was this item number 9 was sold by Mariappa in favor of 1/3 person.
Yes.
Now, pursuant to that, you have purchased this property
From that person.
from that person. When did you purchase?
That was purchased during 1964, 67, my lord. It is during 1967, as per exhibit P5. That is
Yes.
that is 28/6, my lord. My lord, that is purchased during 1967. Give the exact date. That is on, my lord. Exhibit 3/7/1967. 3/7/1967.
Chikka Doddamma, he purchased 1990.
Not Chikkadottam. Chikkaya.
That is Chick 3/7/19.
3/7/1967. That is exhibit P5.
P5.
My lord, what was allotted to my share in the partition was item number 1. Item number 2. And my lord, 3 house sites in the form of item number 6, 7, and 8. My lord, item number 1 is 1 acre and 10 guntas, survey number 99/10. And 99/27 is second item, that is, my lord, 10 guntas. The other 3 items are 20 sites, lord, in 6, 7, and 8. So these 3 items, my lord, were allotted according to our contention as per the oral partition in the year 1955. Around and
So now your contention is this item number 9, having repurchased by you, does not partake the character of the joint family. It is the self-acquired property of this defendant number, the branch of Chikkaya.
Yes, yes. Yes. So, my lord, there are in the plain, my lord, if a lord want to see a document,
No, You can,
But there are two aspects to this one.
so
Whether
the content, so there, in light of, first you have to establish that there was an oral partition. Now you have established by way of the sale deeds which they have executed in favor of a
not only
company.
sale deeds,
Ah.
several public documents they have produced.
Notation entry has been effected to that.
Potential entries were effected, kindly see the
Which are the
exhibits.
exhibits?
Exhibit P4, that is RTC, with regard to 84/2, that is item number 9. Brought this exhibit P4 in the name of Chikkadoddamma.
That is the mother.
Mother, wife of Chikka, that is mother of defendant.
Yeah.
Then on the exhibit D2, that is a mutation with regard to this RTC.
Mutation in regard to the sale.
Mutation with regard to, yes, mutation with regard to the RTC, allot this particular server number, pursuant to the allot sale and
Indeed.
partition. Allot this mutation of the year 1980, around 1980, because my father must have been died in the year 1970s. Because mutation is produced.
Earlier to this, your father's name was there. Chikkaya.
No, for the first time it was mutated in the name of Pavatika,
That is only in 1980.
1980s. My lord, then another, this one is my lord, exhibit P5, P3. This is, my lord, the assessment, house building assessment tax register, in which, my lord, the defendant number 1 name is found. Here and all, I'll show the document.
Yes.
That is regarding property number 6, 7, and 8. Then, my lord, exhibit P5 is the sale deed.
Sale deed pertaining to
84/2, whereof Chikkanna, my father,
purchase the property.
exhibit P6, my lord, the sale deed, whereof, my lord, Mariappa sold it to, Lord, Mariappa sold it to my vendor, that is Chikkakalaya. But this document is subject to, my lord, interpretation. Say, sale with the condition to repurchase. But the court held that it is a mortgage conditional sale under 59C. That is subject to, my lord, the interpretation of your lordship.
Yeah.
My lord, now another DD exhibit is exhibit P2.
Yes.
This is the only artist, my lord, that is pertaining to 99/27. Pertaining 10 guntas. That is first property, second property, second item.
Yes.
This is continued to be at some time, my lord, in the name of Mariappa in Bajar.
Yes.
That is, my lord, plaintiff's father and grandfather. In one column Bajar, one column Mariappa. So, my lord, relying upon only this document alone, the court have come to the conclusion that there exists a joint family and this property joint family property. Apart from that, there is nothing on record.
Yes.
Before your lordship, I have filed application for framing of substantial question of law. I'll come to that later. No, I'll submit. I'll come to that. I'll submit no. Again. My lord, now whether the partial partition is the on whom the burden lies, that's a question. But this particular important thing is to be noted. Other than that,
Yes, sir.
there's a couple of questions of I'll give it to you.
Where is it?
Before that, I will make the submission. My lord, but if it is not a case, my lord, I am saying the property is the purchase not the property which is partition. But is it case where my lord, property was partitioned orally, and what had fallen into the share of Betty's father was alienated. And I took it thereafter. That being the case, burden is not on me to prove that it is held property. That I don't clear.
If partition was not there, and if this document has been treated as a mortgage, then what happens?
There are two eventualities. Lord, assuming that there is no partition. Person who sold the property, Mariappa, was selling the property in the capacity of a co-owner. He was selling the property as a co-owner because there was no partition, assuming that there is no partition. He was a co-owner.
Yes.
Then, my lord, he alienated the property during 1961.
Alienated or mortgage?
That I will come to that interpretation. Even if it is a mortgage, also I will come to that.
Then if it is a mortgage, let us go on one assumption. If it is a mortgage.
If he is a co-owner, had he sold the property to Chikkaya, or Chikkaya is getting his share, but he is entitled to protection of section 44 of the PPA. Because to the extent of that, Manoj will get the right. Section 44.
Yes.
He steps into the shoes of the co-owner. Then the he's selling the
Yes.
I have purchased the property.
Yes.
But now, these people, why he has sold the property? That's all the important. What made him to sell the property?
This Mariappa.
Yes. It may be a kind necessity, or otherwise you don't know. The fact remains that he sold the property as a co-owner.
Yes.
After 40 years of this sale deal, if at all it's a sale deal, whether it's open to his daughter, but when he's selling the property to co-owner, that property was not open to partition. So, whether at this stage she could file put for partition. That's one aspect.
Yes.
Secondly, my lord, if it is a mortgage deed, well, certainly someone should redeem it.
According to you, you have redeemed it.
Assume that well, I redeemed it.
From the joint family income or from the?
Yes. Then it's for them to show that from the family nucleus, I have redeemed the property. Once again, my lord, there is a limitation. But I am just a certain aspect. My lord, if it is held to be a sale, my lord. So far as this property is concerned, this is held to be a sale. What will happen is, then my lord, this person who sold the property, Mariappa, the person who has purchased the property will get absolute right.
Yes.
And my lord, otherwise, there is follows section 92. That is subrogation. I have subrogated the property. Because before this, your lordship had visualized whether there is oral partition good or not. These are all relevant only if your lordship is holding that oral partition is good. the result would be different. The Lordship is saying oral partition is not proved, the things will be different.
Oral partition has to be assumed on the sale by Mariappa and the documents, that is the.
Oral partition has to be, will say that Mariappa, treated father, has independently dealt with the property separately and independently all along. Kindly note.
Which is that document which has been sold? Which is the document in which it says that.
P5, my lord.
P5.
It's with P5 and P6.
With the P5, correct. Is there a typed copy of this?
But before coming to the document, my lord, I would submit there are 3-4 points for your lord to consider to say that there was oral party. One is, my lord, he had independently dealt with the property separately as his own, and he has said, I am selling the property. That is the, so, and before that, he sold another property. That is Exhibit D3. He sold another property. So, my lord, after 5 decades of which, now the partition is filed. Secondly, my lord, one of the defendants, my lord, defendant number 6. Defendant number 6 now, those who was with us earlier, now they are sailing with them. They have admitted in written statement that there was a oral partition.
Dependent number 6
Yes.
is that. Who is the
Defendant
sister
number
of?
8. Defendant number 8.
Who is the sister of Lakshmama?
Yes, one of her sons stated in written statement that there was oral partition. Now this Lakshmama is a humble lady. His husband is a poor bird. He wanted to harass and grab property. That is why this partition is filed. And it was a written statement.
Defendant number?
8. She herself admitted during evidence, my lord, this plaintiff, that she left home, this family house during 1970. Thereafter, she is living in Daman, in Bangalore. So this is our things and now, Lord. Is it sufficient saying one sentence that there is a family comprised of Bajaya, Mariappa and Siddhaya, so that is joint family property? When she herself says she was not in the joint family right from 1970. She has to prove that, my lord, there is joint family in existence and the property is joint family property. Burden cannot be on me because I have not purchased property independently, a third item of property. I have which was given to his share. In turn, he had sold it. So that burden is on her to prove that it is still a joint family property. Court, my lord, straightaway shifted the burden to me.
What were the recitals of the sale deed of this Mariappa? Before sale.
Yes. Recitals, my lord.
Recitals of the sale deed which has been sold by while selling by Mariappa and then from that subsequent person in your name. Which is that exhibit P6.
Kindly look at what exhibit P6. P6, Lord?
Yes.
That is the date 11/10/1961.
Yes.
After 10, 11, 12 lines, ಇಟ್ಟನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಇರುವ after 10 lines. ಇಟ್ಟನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಇರುವ ಹುಲಿಕಲ್ಲಯ್ಯನವರ ಮಗ That's it.
It's, from sixth line,
No, here, I am referring to exhibit P6.
P6. Which
Thereafter,
line?
my lord, after 10 lines, 9 lines, 10th line.
Fourth line is correct.
ಇದರಲ್ಲಿ ಓದಲಿಕ್ಕಾಗುತ್ತೆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಓದ್ಬೋದು
ಅದೇ ಅದೇ ಅದೇ.
10th ಲೈನ್. ಕಿತ್ತನಹಳ್ಳಿ ಹೋಬಳಿ ಕಿತ್ತನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಕುರಿ ಕಲ್ಲಯ್ಯನವರ ಮಗ ಚಿಕ್ಕ ಕಲ್ಲಯ್ಯನವರಿಗೆ ಇದೇ ಕಿತ್ತನಹಳ್ಳಿರುವ ವಜ್ಜಯ್ಯನವರ ಮಗ ಮರಿಯಪ್ಪ ಆದ ನಾನು ಬರೆಸಿಕೊಟ್ಟ ಜಾಮೀನು ಕಂಡೀಷನ್ ಕರೆಯ ಪತ್ರದ ಕ್ರಮವೇನೆಂದರೆ ಇದೇ ನೆಲಮಂಗಲ ತಾಲೂಕು ದಾಸನಹಳ್ಳಿ ಹೋಬಳಿಯಲ್ಲಿ ಕಿತ್ತನಹಳ್ಳಿ ಗ್ರಾಮದ ಬಳಿ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಇದ್ದು ನೋಡಿ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಇದ್ದು ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಸರ್ವೆ 84ನೇ ಕೋಡ್ 2ನೇ 84(2) ಬರುವ ಜಾಮೀನು ಚೆಕ್ ಬಂದು ಸೋಯನ್ಸು ದಟ್ ಇಸ್ ದಿ ಬೌಂಡ್ರಿ ಮೈ ಲಾರ್ಡ್. ದೆನ್ ಲಾಸ್ಟ್ ಲೈನ್ ಈ ದಿವಸ ನಮಗೆ ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ಈ ದಿವಸ ನಮಗೆ ಗವರ್ಮೆಂಟ್ 200 ರೂಪಾಯಿ ಬೈ ಬ್ಯಾಂಕ್ ಟೈಮ್ 200 rupees ಕಂಡೀಷನ್ ಕ್ರಯ ಮಾಡಿ ಬಾಪ್ತು ಮೊದಲನ್ನು ಪೂರ್ತಿ ನಗದಾಗಿ ಕಂಡು ಸಾಕ್ಷಿಗಳ ಸಮಕ್ಷಮ ಈ ದಿವಸ ಸ್ವತ್ತನ್ನು ನಿಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ಬಿಟ್ಟಿರುತ್ತೇನೆ. ಆಫ್ಟರ್ ದ 2 lines ಈ ಲಗಾಯಿತು ಇದಕ್ಕೆ 2 ವರ್ಷ ವಾಯಿದೆ ಗೊತ್ತು ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. 2 lines after that. ಈ ವಾಯಿದೆ ಒಳಗಾಗಿ ನೀವು ಈ ಹಾಲಿ ನಮಗೆ ಕಂಡೀಷನ್ ಮಾಡಿಕೊಟ್ಟಿರುವ 200 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ಮಾಡಿಕೊಂಡು ವಾಪಸ್ ಪಡೆದು ಹಾಗೇನಾದರೂ ನಾವು ಈ ಒಳಗಡೆ ಇವುಗಳ 2 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ಮಾಡದೆ conditions are not there, it becomes this one. So this is how it is written. He had a kata for that. And he transported to my lord Tikkakalaya to the 61, saying that within 2 years he will take it back. If not, my lord, he is to continue. The seller.
The 2 years expires when?
That is 63. Yes. No, lord. Come to my kindly come to my exhibit T5. But before that, whether this is a mortgage, if this let to be held to be a mortgage, then my lord kindly look at 59C of Transfer Property Act. Ostensibly sells the mortgage property on the condition that on default of payment of mortgage money on a certain date, sale shall become taxable. On condition that such payment being made, it shall become void. On condition such payment being made, the buyer shall transfer property seller. Transaction called mortgage condition sale and the mortgage by condition sale, provided no such transaction between.
What does the trial court and the first court appellate court? What does the appellate and first appellate trial court and first appellate court hold regarding this document?
This document they randomly said no, it is this mortgage. That's all. Nothing further. Kindly come to the exhibit P5. You can not exhibit P6. There's no mentioning about my lord loan being taken or a money being taken in the nature of a creditor or a my lord person who lent the loan. It was a kind where my lord he was transferring his own property, though they stated that my lord conditional sale. In such circumstances, my lord, I'm referring to one of the judges of Supreme Court recent judgment. Same set of fact, court held that it is not a repurchase, it's not a habitual sale, okay, of repurchase. Condition, with the condition of repurchase. But kindly come to exhibit please 5, my lord, I will, because I don't know the copy of last, because already last, one document.
Which is that? That is the document which is the,
I have purchased it.
you have purchased from that person. who-
Kalaya.
Yes.
But ಇತ್ತನಹಳ್ಳಿಯಲ್ಲಿ ಹಾಲು ಮಟ್ಟ ಲೇಟ್ ಕುರಿ ಕಲ್ಯಾಣ ಮತ ಸ್ಥಿತಿ ಕಲ್ಯಾಣದ ನಾನು ಬಳಸಿಕೊಂಡ ಸ್ಥಿರಾಸ್ತಿ ಶಕ್ತಿನ ವಾಪಸ್ ಕರೆಯ ಪತ್ರ ಕ್ರಮವೇನೆಂದರೆ ದಿನಾಂಕ 11/10/2061ರಂದು ಮಂಗಳೂರು ತಾಲೂಕಿನಲ್ಲಿ ನಿಮ್ಮ ಶಾಸನನಾದ ಮರಿಯಪ್ಪನವರು petition ಕೈ ಮೂಲಕ ಪಡೆದ ಸಾಧನದಲ್ಲಿರುವ ಇದೇ ಶರೀರ ನಮಸ್ತು ಸತ್ತಗಳನ್ನು ನಿಮಗೆ ಗವರ್ಮೆಂಟ್ ರೇಟಿನಲ್ಲಿ ₹2 ಶುದ್ಧ ಕ್ರಯಪತ್ರ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಶುದ್ಧ ಕ್ರಯಪತ್ರ.
Yes.
Right, this is the document of 961 and 67.
Continue tomorrow. Monday 2:30. Maybe we have done. 2:30. Add it, yeah, for the delay. Then 24. 23rd, 3:30, we will take. 3:30. Because we have already given 2 matters. Please load on. Next. 23rd at 3:30. Because we have got other matters which have already heard, writ petitions. How the writ petitions done happen? You come at 2:30, we will see, we'll take up your matters and then we will take.
May.
Sorry. It's already framed by this court, right? Additional.
ಒಂದೊಂದು ಪೇ ಮಾಡಿದ್ದಾರೆ.
Yes, sir. Have you given the copy to the other side? We can frame this, we'll see whether it is necessary. Because if we are hearing this, it is as good as hearing a reappeal now. We have to frame the substantial question now. And it would be better if you frame and then answer it. At 2:30 on Monday. At 2:30, top of the list. Yes. Okay, we have got 50.
37, I got the appellate. Very short point is all. The question is not whether plaintiff is able to prove the existence of joint family property and joint family. That is the only issue.
Right, now we have already into so many parted matters. You saw, no, this court is, and all, or 2 appeals, 3 appeals. So we have very shortage of time for the next. Correct, you may take 15 minutes, but we have to hear you, right? We are hearing, see, senior counsel says, you are saying, how is this court going to say? We are already, how many matters, Ivra? Monday? 3. 5 for further hearing.
we get except 25th and 26th. 26th, your lordship has been on board.
Next week only we are sitting only for 5 days, right? Then
Yes, sir.
how are we? So we will only go for further hearing. Request other members to take your chance after the vacation. No? No, let us finish first this is submission, no? No, you take your chance after summer, after Dasara vacation. See, unnecessary, we have to make you all wait. Let us complete whatever we have taken to task. In the week commencing from 14. Release this matter after the ensuing Dasara vacation in the week commencing from 14. 19 bartered matters we will hear. Wednesday. Yes, Mr. Next week, it is difficult. We are not heard you, right? Only heard matters we are hearing now. Only 1 week, 4 days, 5 days counting. Then to carry out the file is very difficult. Yes. To take your chance after Dasara vacation. This matter after the ensuing Dasara vacation 2024. Yes. 45. IA 1 of 24 for direction filed by the counsel for the respondent number 1. You have filed. Then if they don't file, what should we do? Can we insist them to file objections? You want to file objections or not? You're filing? When you're going to file? Appellate counsel seeks time to file objections to IA number 1 of 24. As a final chance, a week's time is granted. Next week, not possible. 2 weeks' time is granted. List this matter in the week commencing from 14th October. Yes. All other matters would come after the Dasara vacation. ಏನು ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಎಲ್ಲಿ ಅಲ್ಲ ಅವ್ರು ಬರ್ಲಿ ಅಲ್ಲ ಅವ್ರು ಇದಾರಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಂಡುರಂಗ್ ನಾಯಕ್ ಏನಾಗ್ಬೇಕು ಡೇಟ್ ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ 25 ಆಗಲ್ಲ ಈಗ ಮುಂದಿನ ವಾರ 4-5 ದಿವಸ ಇನ್ನು ಸಮ್ಮರ್ ಇದು ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ಳಿ ಡೇಟ್ ಕೊಡಿ ಇನ್ ದ ವೀಕ್ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ 21st. ಬಾಕಿ ಎಲ್ಲ ಹಂಗೆ ಕೊಡಿ 21st. ಪದ್ಧತಿಯರಿಗೆ ಎಲ್ಲ ಹಾಕೊಳ್ಳಿ ಯಾವ್ಯಾವ ಇದೆ.